part of the legislative process. Sorry, somebody has her hand up. Should I?
You carry on. That'll just be a question for later.
Okay. In doing so, the bill reinforces the due diligence that should be front and center in making new laws. Unfortunately, such cost-benefit calculation is the exception rather than the rule. I want to say a few words about two principles outlined in Clause 8 that seem to have caused controversy. First, the Suitable Compensations Clause. The clause states, legislation should not take or impair property without the owner's consent unless certain requirements are met. The requirements include that there is a good justification for the taking or impairment and fair compensation is provided to the owner. I'm not sure why this is controversial. Would you rather have the government did not provide suitable compensation if it took your property? I also note that this language is very similar to the Fifth Amendment of the US Constitution and part of their Bill of Rights. The US Constitution is the second oldest written constitution, and this was ratified back in 1791. So this idea, or the takings clause, is not new. The second issue relates to the ability of the legislature to pass public interest laws, such as environmental regulations. Nothing in the bill prevents this. Clause 8 clearly states that the public interest must be considered as part of good lawmaking process. The bill states, very briefly, legislation should not unduly diminish a person's liberty, etc., except as is necessary to provide for or protect any such liberty, freedom, or right of another person. Most importantly, the bill is non-binding. A former colleague of mine put this well. Think of the bill as nutritional labeling. You can still put in all the saturated fat that you want. You just need to let the public know about it. In conclusion, I support this bill not only because it is good economics, but because it makes good sense. Thank you very much. I'm happy to answer questions.
Thank you, sir. We've got first question from Dr. Deborah Russell.
Thank you for your submission, Professor Trudrey. The Suitable Contemplations Clause, legislation should not unduly diminish a person's liberty. Can you tell me how you're interpreting that phrase, a person's liberty?
I interpret this in the sense of what we do in economics or other policy making in the terms of externalities where one's actions may have implications for somebody else. And therefore, there is a need to evaluate who's being benefited, who's being harmed.
So which notion of liberty are you using? That's a very contested term.
I understand that, but that's not something that is. It may be open to the courts to evaluate at a future point. But the question is liberty in the sense of economic liberty, personal liberty.
So that's not especially helpful. What about it's phrased in very individualistic terms? How do you see how this might impact on group property or the notion of groups versus individuals? And what thinking have you put into that?
There are, as an economist and as somebody who specializes in what is called public economics or the notion of public goods, this is a very, very key concept, this contention between, say, individual liberties, individual rights versus the collective action problems or the common good. And my interpretation is that nothing in the bill prevents any of that. So you might be putting on an interpretation on this that reflects your perspective or your context, but the language of the bill does not necessarily say anything along those lines because it clearly states that the public interest must clearly be taken into account in making laws. So essentially, what we're talking about here is the utilitarian concept of the greatest good of the greatest number. That's how I interpret this.
Well, I find that utilitarian notion not very helpful in collective rights. I better, as a political theorist, I've got some very well-considered views on that. I'll hand over to the next person now.
Sure. That's your view, ma'am.
Yeah. Thank you, sir, for your submission. Sure. So we are out of time, Francisco, so I hope to get you on the next one.
Okay, thank you very much.
Thank you very much.
Thank you.
We will now move to Annie Mccay, if she's online.
right, what's going on?
Oh, there we go. Welcome, Annie. Is that how to say your name?
Annie Mccay, can you see me?
Can hear you but not see you.
Don't know why that is. It was working this morning.
No problem. We'll just kick off because we're a little bit over time, but we've got 5 minutes with you. So if you'd like a little bit of question and answers at the end, please just
hang on. It's just asked me to start my video, so perhaps there we go.
Perfect.
Can you see me?
Morena,
Right.
welcome.
All right.
In your hands.
Tēnā koutou, I'm opposed to this bill for the following reasons. It has nothing to do with its proclaimed objective of improving the quality of regulation. Its true goal is to further embed neoliberalism. The bill will entrench and extend the inequality that has always existed within the colonial state by allowing the wealthy even greater freedom to maximise their prosperity without regard for the social, economic or environmental consequences. By forcing policymakers to justify honouring Te Tiriti o Waitangi, the bill will create a default setting of non-compliance with Te Tiriti. It will establish what has aptly been referred to as an anti-Waitangi tribunal, a regulatory standards board of unqualified, unrepresentative, unaccountable and self-interested corporate elites handpicked by the Minister to ensure conformity with neoliberal anti-treaty principles. The process followed thus far, including this select committee charade, is in breach of Te Tiriti o Waitangi and of best regulatory standards. It is a classic case of what I call insultation, of staging a sham consultation exercise with no intention whatsoever of paying any heed to the feedback it generates. Now, the Minister's response to the tidal wave of opposition to this bill has been to launch into a frankly childish tirade about bot-generated and fake submissions, assertions for which no shred of evidence has been produced. In truth, opposition to this bill is coming from all quarters. It includes carefully articulated submissions that draw on an extensive range of expert knowledge and relevant experience. It covers a raft of concerns being thoughtfully expressed by real people who understand the detrimental impact that this bill will have on them and on the things they care about. The ACT Party is clearly wedded to its vision of an Aotearoa run by a clique of short-sighted, self-interested corporate elites who prioritise short-term profit over all else. The Minister and his minions are determined to ignore all expert advice as to the likely consequences of their actions. So there's clearly no point wasting my breath on ACT. For that reason, my remaining comments are directed solely towards ACT's coalition partners. When Ganesh Nana submitted on the Treaty Principles Bill, he asked whether there were any adults in the room who were willing to stand up and take responsibility. To the committee members from New Zealand First and the National Party, this is your opportunity to stand up. National Party members will know that your predecessors have not been afraid to curtail the behaviour of the willful ACT child on this issue. Various iterations of this bill have failed in the past because governments of all political stripes, including national, have rejected it. The ACT Party has gained a level of influence that is out of all proportion to the level of support it gained in the last general election. The National Party has lacked the backbone to stand up to its favoured coalition partner, appeasing it by entertaining its every whim, regardless of how ill-conceived or unpopular its proposals might be. National and New Zealand First currently face the spectre of this parliamentary term going down in history as the period when the ACT Party governed. As coalition partners, you have been completely upstaged, reduced to the role of chorus line in the ACT pantomime. It's now time to show that you're capable of stepping forward, playing your role as adults by rejecting this shameful bill in its entirety. Alternatively, you could strip the heart out of the bill before it's returned to the House for its second reading. You could do this by firstly removing the establishment of the Regulatory Standards Board, and secondly by removing the Clause 8 principles, replacing them with a set of principles that are modelled on current best practice for regulation. If not rejected outright, this bill should be returned to Parliament as an empty vessel. This would be a fitting end for the flagship proposal of a minister who has treated the views of the electorate, expert advice, his coalition partners and parliamentary processes with such overweening disdain. The time has come for the National Party and New Zealand First to reassert your identity as political parties in your own right, rather than being seen as mere enablers of ACT. Failure to step up will result in your forever being perceived as incompetent and impotent. History and the electorate will judge you accordingly. Tēnā koutou.
Kia ora, thank you for your submission. We are at time, unfortunately, so we don't have time for questions, but thank you for your submission. We are going to move now to the Asian Legal Network. I'm not sure who's fronting that speaking for them. I can see you online. Good morning, Asian Legal Network. Thank you. As an organisation, we have you for 10 minutes, and just encourage you to leave a few minutes at the end for questions and from MP colleagues. In your hands.
Kia ora koutou, my name is Shireen Lee and I'm appearing with Darren Iwi, and we submit on behalf of the Asian Legal Network.
Sorry, are you able to turn up or speak a bit louder? It might just be my end, but you're coming through a little bit quiet.
Okay, I will speak a bit louder. We strongly oppose the Regulatory Standards Bill. We are an organisation of lawyers, former judges, academics, researchers and community advocates. As part of our advocacy, we provide you, lawmakers and government officials, with perspectives on how proposed legislation can affect Asian peoples, especially the most marginalised in our communities. To this end, we strongly oppose the Regulatory Standards Bill. We will take our written submission as read, but today we want to focus on the following points. First, how this bill amounts to constitutional change by stealth. Second, the disproportionate effect of this bill on Asian communities. And third, we will focus on our proposed recommendations to the bill if it does progress further. Importantly, we want to emphasise that this bill essentially erases Te Siriti o Waitangi, which contradicts existing parliamentary guidance. We strongly support the submission from Te Hunga Roia Māori o Aotearoa on this point. Turning to our first point. This bill entrenches libertarian values into our lawmaking process without a democratic mandate. The values in Clause 8 prioritise deregulation, business interests and private property rights. When the board reviews primary and secondary legislation against a set of libertarian values, it essentially requires the lawmaking process to favour such values at the risk of other equally important socio-political and environmental factors. These proposed values are far from what the majority wants. In fact, they're all proposed by a minority political party who do not represent the views of all citizens in Aotearoa, New Zealand. Even at the initial consultation phase of this bill, 88% of submitters opposed the bill. There is clearly no democratic mandate for this bill at all. To our next point, there is no justifiable policy rationale for this bill. This bill ironically creates further legal uncertainties by entrenching contested libertarian values into the lawmaking process. The board effectively adds another layer of regulation, undermining the bill's very own purpose of reducing unnecessary regulation. I will now leave Darren to address the remaining points.
Thank you for sharing. I'm going to turn now to our second point as to how this bill will disproportionately affect Asian communities. And I want to pause just to note that for the committee, Asian communities are not a monolith. There are huge amounts of diversity within our communities. And yet despite this, Asian communities are often disproportionately underrepresented, whether this is in government, in parliament, in policy making, but also face many forms of inequities and structural disadvantage, whether this is in healthcare and health outcomes, whether this is also due to language barriers that need to be addressed. Why this bill will be a problem is because by taking a libertarian approach, and via Annie has already spoken at length about this, a libertarian approach takes individualism and a very strained view of equality within their definition of what rule of law requires, and that question to the first speaker has already addressed this. It's a very narrow approach. What this does is that it sets up very poor lawmaking. It doesn't give good lawmaking tools to consider how structural disadvantage can create patterns that are negative in the future. And it sets up our parliamentary processes to also signal to national policy statements, to policymakers, that this is the direction that policy is going to take. On the ground, what we are concerned about is that a lot of initiatives that are already set up. We're talking about things like health services that focus on Asian communities. We're talking about groups in Te Whatuora that have this focus. Even some legislation, including the public sector related legislation, talks about inclusion and diversity. Now, from a libertarian point of view, and I will even take the words of the first submitter, Anani on this, you know, when he talks about cost-benefits analyses, I think that question is very poignant. Under whose value system is considered a benefit? Because we often find that minority groups are often seen as the trade-off. Minority groups are often seen as the thing that, you know, won't be beneficial for the majority, so that's something that's likely to drop off. This analysis can apply far and wide to other marginalised groups within our communities. We're talking about our disabled whānau, our LGBTQIA+ whānau, but also many other groups that this analysis can apply to. What we're saying from our community's perspective is that New Zealand, firstly, will be a diversifying community, whether we like it or not. As a result of that, our legislative tools need to be able to consider long-term effects, not just the individual. If we do this, we're actually undermining our ability to plan for the future, and this will also have negative economic impacts if we don't consider long-term problems and address them now. So that's our concern, especially with Asian communities as the fastest growing and diversifying demographic in Aotearoa. I only want to touch on really briefly the recommendations we have. Our primary recommendation is this bill should be thrown out in its entirety. There are no amount of amendments that can actually save it. We agree with Whaia Ani that the best thing we could do is actually remove Section 8 completely. In Clause 8, our paragraph 28 in our submission gives a whole raft of suggestions to change. This includes requiring that all legislation from now maintain consistency with He Whakaputanga, the Declaration of Independence, and Te Tiriti o Waitangi as a good starting point. And even if there was a board, it should take a holistic and inclusive, diverse approach to its evaluation, not the way that it's currently drafted. In short, the constitutional changes, the disregard of Te Tiriti, and the fact that it will have a disproportionately negative effect on Asian communities is of grave concern for us, and we hope that this committee will recommend that it gets thrown out. We'll pause now to engage with any questions that the committee has for us.
Thank you. We've got about 3 minutes left. First question from Debbie Narewa Paka.
Morena, thank you through the chair, and thank you for the presentation this morning. My question, and you have sort of talked about the negative impact. From your view, the consequences of deregulation in the name of equality to our Asian community, to tangata tiriti in Aotearoa, what might be the consequences? Gosh, I hope I said that well.
So the consequences in practice is simply the removal of anything that talks about equity, right? Because that's how equality is always framed, as the challenge to anyone that is slightly different gets extra, quote unquote benefits or special privileges. That's how equality has always been framed, and there's always a risk that that's what's going to happen, and lots of different services will get cut as a result of that. It could create a chilling effect on government policy, that government proposals that go into cabinet in the future might say, oh, we've got to stray away from anything that'll actually impact good equitable outcomes. And again, it's not limited to Asian peoples. We know that many other communities will likely face this as a consequence.
Thank you. A quick question from me. In your submission 2A, you say the bill erases Te Tiriti o Waitangi from the constitutional landscape. I was just wondering whereabouts in the draft bill you can guide me to where it actually does that or says that.
I think the fact that it's silent is the problem. And something as important as this.
So it doesn't actually say that. Is that correct?
That's the point, is that the significance of this, the way that the board is structured, the signalling of what it does, is to remove references to that. And the more that we invest in things like a board, this taxpayer money that's going to a board to review legislation in the future, is not going to put a focus on something as significant as that. And that's why we have important values like the rule of law, like the role of courts. These things are put into there because this bill is building on our constitutional framework. And at the very silence on Te Tiriti is the problem, right?
Are you aware that the Bill of Rights is also silent on the Treaty of Waitangi?
And I think that the Bill of Rights, there's a lot of jurisprudence about the way that Bill of Rights should interact with Te Tiriti frameworks. There are decolonial views on human rights frameworks, Ryan, that we're happy to send an additional submission to you about. Lots more can be done to advance when the Bill of Rights was drafted in 1990. I think the Waitangi Tribunal, many parliamentarians have done a really good job since then to advance us, and I don't think we should stop moving in that really positive direction.
Francisco, have you got time for a quick question, or do you want me to leave you to?
Yeah,
okay,
just a quick question. In your paragraph 22, you talk about how the bill will exacerbate inequities faced by various Asian communities and undermine protections and measures that support equity. Can you give a concrete example of an exact thing that's serving Asian communities that this bill might undermine?
Yeah. So if we look at just a lot of our footnotes speak to specific pieces of legislation that reference equity, including the New Zealand Public Health and Disability Act, Public Services Act 2020, sections 73 to 75. We also think that it's the flow-on effects that's our problem. There are many Asian health services that we can list, and again, write to the committee as additional submissions if that is helpful on the specific organisations that we're talking about that might risk having their funding cut in the future. Te Whatu Ora has a specific organisation that has ethnic communities and Asian communities that serve in the Waitemata, North Shore and West Auckland that we know. Is there a risk that their funding might get cut if this is the way that legislation might be viewed in the future? And we think that that's a risk that's not worth us taking.
Very good. Thank you for your submission. Appreciate that. We're going to move now to the Citizens Advice Bureau New Zealand.
Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Good morning.
Good morning. Thank you very much for allowing us to be heard on our submission. Citizens Advice Bureau New Zealand ngā pou whakawhiranaki o Aotearoa strongly opposes the Regulatory Standards Bill and requests that it not proceed. Firstly, a brief overview of the Citizens Advice Bureau. We're a nationwide and locally based community organisation that provides people with free, confidential and independent information, advice and advocacy. We are based in 80 locations around Aotearoa, New Zealand, and our service is provided by 2,000 trained CAB volunteers. In the past year, CAB's helped with over 300,000 client inquiries on everyday issues such as housing, relationships, immigration, consumer problems, and employment issues. We also use what we learn from our clients to speak out for fair laws, policies, and services, and to challenge those that harm people's rights or well-being. The fundamental values and commitments of our organisation, particularly to the principle of partnership under Te Tiriti or Waitangi, compel us to oppose the Regulatory Standards Bill. We wish to focus on two key concerns. One, that the bill, which could have significant impact on the constitutional arrangements of our country, was developed without the agreement of Māori as signatories and partners to Te Tiriti or Waitangi, and without reference to Te Tiriti. And two, that the bill introduces a narrower set of principles to judge legislation than those we have currently in the legislation guidelines, which risks diminishing important rights and the well-being of both people and of the environment in which we live. I'm now going to go into both of these issues in more detail. In relation to the first, it is our deeply held concern that this bill was developed without consultation with or the agreement of Māori as treaty partner. We note that the Waitangi Tribunal, in its interim report on the bill, found that if it were to be enacted, the bill would be of constitutional significance as it seeks to influence the way Parliament makes laws and therefore is inherently relevant to Māori. The tribunal also found that if it was enacted without meaningful consultation with Māori, it would be in breach of the principles of Te Tiriti. And distressingly, the tribunal found, and I quote, "These breaches have caused or will cause prejudice to Māori, and the Crown's actions in progressing the policy without engaging with Māori adequately has been damaging to the relationship between Māori and the Crown." The tribunal also found that the absence of meaningful engagement with Māori on the potential but unknown impacts of the legislation has caused stress and uncertainty, resulting in further prejudice. We consider it to be wrong and unjust that the current government, acting as the Crown, one treaty partner, has developed and proceeded with this legislation without the agreement and involvement of the other treaty partner. Furthermore, we note that the Regulatory Standards Bill does not require new laws to be consistent with Te Tiriti or Waitangi. We are concerned that the bill's silence on Te Tiriti may unjustly alter the legal and political status of Māori as treaty partner. Given the history of breaches of Te Tiriti by the Crown, we consider that extreme care should be taken to engage meaningfully and in good faith with Māori as treaty partner in regard to anything that has the potential to limit and change their rights under the established meaning of Te Tiriti. The fact that this has not happened is wrong. Proceeding with this bill risks severely damaging the Crown's relationship with Māori, undermining trust and breaking down social cohesion in our country. We consider that the government, acting as the Crown and our representative, has not acted in good faith in relation to Māori as treaty partner to the Crown, a fundamental obligation that it has. On this basis alone, the Citizens Advice Bureau opposes the Regulatory Standards Bill and requests that it not proceed. We also oppose this bill on the basis that the principles in the bill have a narrower scope than the existing legislation guidelines. This is our second key concern, that many important principles by which legislation is currently judged and the rights they relate to will no longer be included when assessing legislation. This risks diminishing the well-being of people and the environment in which we live. Citizens Advice Bureau contributes every day to the well-being of people and communities. Our volunteers empower people with information about their rights and obligations. These flow from legislation. Legislation creates a framework for our well-being. Our expectations of each other, of our government, of our society, and our rights in relation to these. It is vitally important that the principles against which legislation is judged protect and hopefully enhance the well-being of people and the environment in which we live, and certainly reflect existing fundamental rights. We have already spoken to the fact that the bill is deeply flawed in that it does not include reference to Te Tiriti or Waitangi. Additionally, the fact that the principles in the bill have a narrower scope than the existing legislation guidelines mean that many other important principles by which legislation is currently judged and the rights that they relate to will no longer be included. Important principles have been left out, such as enhancing human well-being, protecting human rights, protecting the environment, protecting the rights and interests of future generations. This risks diminishing the well-being of people, communities, and the environment. We note that the Ministry of Regulations pointed to the fact that aspects of good legislative design and lawmaking that are currently in place have been left out of this bill, and I quote from page 5 of the Regulatory Impact Statement. The principles that would be established under the Cabinet paper proposal are selective, i.e. they do not cover all aspects of good legislative design and lawmaking that are currently covered in the legislation guidelines, and some of them are novel in that they do not align with or go further than generally accepted legal values and concepts in New Zealand and relevant overseas jurisdictions. This statement by the Ministry points to the fact that the principles that the legislation is seeking to introduce are lesser than what the regulatory system has currently with the legislation guidelines, and also includes untested legal principles that are novel. This introduces the risk of the unknown and potential for harm into our legislative framework. The regulatory impact statement states that there ends up being a high level, even if there ends up being a high level of compliance with the new principles, the impact on the quality of regulation is uncertain, meaning the justification for this bill under its own stated purposes is uncertain. This fact, combined with the fact that there is no compelling problem definition or evidence regarding the inadequacy of the current regulatory system, means that unnecessary risk is being introduced into our legislative framework through untested novel legal principles for no good reason. We strongly submit that this deeply concerning and flawed legislation in its entirety should not proceed.
Thank you, Kerry, for your submission on behalf of CAB. We've actually met time, so unfortunately we haven't got time for questions, but I'll keep you up for the next ones, Mark and Debbie. So we're now going to move to 350 Aotearoa. Have we got Adam there?
Kia ora, Ryan.
Kia ora, Adam. You've got 10 minutes. I just remind you to try and maybe save a few minutes at the end for Q&A.
Ka pai. Kia ora, tēnā koe tēnā koutou committee. I'm here, I'm Adam, and I'm here on behalf of 350 Aotearoa. We're a climate justice organisation committed to ensuring that Aotearoa takes decisive and equitable action on climate change. We previously submitted on this bill during the consultation process by the Ministry of Regulation, and will take our submission as read by this committee. Ultimately, along with the vast majority of other submitters, we think the bill should go on the compost heap. This compost heap right here, right where the this compost heap right here, right where the bill should be, and that we say that as well because we know that ultimately, 0.33% of submitters during the consultation supported the bill. Real people, real submitters taking times out of their lives to oppose this anti-democratic bill. And so we're going to deliberately choose not to engage with the select committee process, and we're not going to speak to the policy intent of our submission because we believe this select committee process is so fundamentally flawed and exclusive that we do not want to legitimise it further. And plus, this government has repeatedly ignored expert evidence and the overwhelming majority of submitters' views, not to mention the repeated dehumanisation of submitters by this bill's author. Instead, we want to amplify and highlight that tomorrow, at Tuesday, 8th of July at 9 a.m, outside this building on Parliament grounds, a People's Select Committee will convene to amplify the huge number of oral submissions that this Parliament is refusing to hear in opposition to this dangerous bill. And we believe that that will be a far more inclusive process, actually, than the one that's currently being run by this Select Committee. Tēnā koe, we welcome any questions.
Okay, thank you, Adam. Very succinct. We'll start with Francisco Hernandez. You're on mute, Francisco.
Apologies, Chair. Thank you, Chair, and thank you, Adam, for your submission in 350 as well. In your submission, you talk about how we need enhanced, not diminished regulatory capacity. Can you talk through concrete examples of what that might look like?
Absolutely. So the regulatory capacity overall as a country we need is far greater. So I'll give you a great example is of mining. So we're currently working a lot on opposing a coal mine on the West Coast. And of course, the regulation currently governing coal mining and mining in general in Aotearoa is far too minimal. And there are many mines across the country that actually have never applied for consent in the first place. They're operating illegally. And when reported to MBIE for illegal mining, MBIE either does nothing or they make the mining company pay the royalty they would have had to have paid anyway, right? So it's effectively like saying, it's like a parking ticket, right? If the government is not spending any money actually investigating illegal mining, and the government is not actually putting any fines on those who engage in illegal mining, why would I ever buy a parking ticket if the fine is the same price the ticket would have been anyway, and there's no parking wardens happening? And that is just one example of that's a tiny example of the many, many other areas in which we need far more inclusive, far more effective regulation in Aotearoa, from the mining sector to waste incinerator sectors, of course, to the current fast bill process, which we know undermines regulations from local councils and others as well. So those are a few examples of why we think we need much greater, enhanced, Te Tiriti-centric regulatory capacity in Aotearoa.
All right, thank you, Adam. We don't appear to have any more questions. So, thank you again for your submission.
Thank you, Ryan, and we look forward to seeing everyone outside tomorrow. Hapai.
Hapai. We're now going to move to ANZCA, Australia New Zealand College of Anaesthetists, if they're ready to present.
Kia ora koutou. My name is Dr. Rachel Dempsey.
Good morning. Welcome, Rachel. And just to give you some guidance, we have got 10 minutes, but encourage you to leave a few minutes at the end of your presentation just for some Q&A.
My name is Dr. Rachel Dempsey. I'm the chair of the National Committee of the Australian College and the New Zealand College of Anaesthetists. I'm a consultant anaesthetist here in Wellington Hospital, and I'm joined on Zoom by my colleague, Dr. Brendan Little, an anaesthetist in counties Manukau and Auckland. The Australian New Zealand College of Anaesthetists is one of the largest specialist colleges in Australia and New Zealand, responsible for the training, assessing and setting standards for all specialist anaesthetists and specialist pain medicine physicians in Australia and New Zealand. Aotearoa, New Zealand is one of the safest places in the world to have an operation. This is because of our existing regulatory systems. ANZCA opposes the bill, which we think is unnecessary, duplicative, and may undermine health system regulation. We appreciate the opportunity to talk to the points raised in our submission and why we see the bill as a threat to the provision of safe, equitable healthcare in New Zealand. The 3 points we'd like to cover are how our current regulation is vital to our high-quality healthcare, how lack of engagement with Māori and Te Tiriti Waitangi principles has a health consequence, and how narrowly focused principles are contrary to good health regulation. As regulated, trained and qualified health practitioners, we are trusted to deliver safe anaesthesia to you, your whānau, your loved ones. In return, we trust that medicines and devices that we use are safe and effective, that staffing levels are appropriate, that our staff are appropriately trained, that we work with. We want to know that our medicines are doing what they want to do. They're up to standard, they're not contaminated, they're not counterfeit. We want to know that our operating theatres are up to standard and that all of our allied health services are up to standard. We need to know that the right people are in the right jobs, working in the right scopes of practice. This complex network of regulations is constantly undergoing review, informed by trusted health expert advice. We need to keep up with the latest evidence-based healthcare practices. This bill proposes a ministerially appointed board, which simply would not be able to have the expertise needed to assess health regulation amongst all the other roles it will be performing. We had concerns with the Medicines Amendment Bill, where doctors and pharmacists knowing about medicines were replaced by ministerial appointees on a committee talking about medicines that they would not understand. The college is concerned about the very wide scope of the bill, covering all proposed and existing legislation. This could lead to piecemeal, haphazard review of all sorts of regulations. We saw devastating health consequences around water regulations, resulting in a health outbreak of gastroenteritis. We don't feel that we need another regular review process because most of the legislation includes provisions for regular review under the Health Practitioner Competence Act every 5 years. There are other established appropriate mechanisms for good regulatory care. This bill either duplicates or interferes with these very specific areas of regulation. We feel that a high price tag could be better invested in health care itself. We also trust when things go wrong, there are processes in place to put them right. We have several through the Health and Disability Commissioner. We look at how we improve in our health systems and engage with patients to get better health outcomes. Brendan, would you like to say something as well?
Yeah, thanks, Rachel, and thanks to the committee. We're worried about the lack of engagement with Māori and the absence of Te Tiriti o Waitangi principles. The exclusion seems deliberate and could harm Māori health and health equity within Aotearoa. ANZCA acknowledges Te Tiriti as a key document that shapes Aotearoa's history and culture, and it's influenced our approach to medical education, research, and community engagement. Cultural safety is a must in all healthcare or health practitioner training, and it's part of our ongoing professional development within our anaesthetic college. We think it's crucial to understanding people's situations and being able to communicate effectively so people have the information they need to make decisions about their health and access things like information, services, and treatments fairly. There are initiatives in place at both universities within New Zealand that offer medical training that have improved the numbers of Māori and Pacific doctors in our country. Without these colleagues in their essential roles, we'd be cutting off an important point of access to care for our Indigenous population. And initiatives like these need people with a solid understanding and background in the complex current systems in place to support and improve them. And I think it's unlikely a small regulatory standards board with 5 to 7 people or the overseeing minister would have the experience needed for this. Similarly, outsourcing procedures from public to private facilities is a hot topic right now within health. And it's relevant to us particularly as specialist anaesthetists. The patients are a select few that have low enough risk to be treated in private facilities because of factors like age, BMI, and significant comorbidities. And it's well known that because of ongoing health service inequity, Māori are overrepresented in those groups that would be excluded from the outsourcing. So clearly changes to health system regulations like private outsourcing or like the university initiatives directly affect Māori health in New Zealand. But this bill doesn't specify how Māori will be consulted, and it doesn't align with Te Tiriti principles. It's a huge topic. I think it's incredibly important, but we've got limited time, so I'll pass back to Dr. Dempsey.
The principles focus on individual and property rights, but they don't place emphasis on evaluating regulation in terms of the wider public good. The weight of the bill is around removing consideration on individuals and corporate short-term economic gains are involved. We are worried that the effects of this might not be seen for some generations. As doctors, we would argue that the significant improvements in both individual and population health in New Zealand have all been because of population health measures, sewerage, clean water, immunisation, fluoridation, investment in public health education, health promotion and infrastructure. These are the gains that we need to make. There's considerable financial and health risks when corporate interests are privileged above the common good. It's easy to see the improvement in population health when corporate interests have been made subject to regulation, for example, in the tobacco and alcohol industries. We also think the example of folate enrichment in flour was delayed for some time, causing a number of defects in children born without this important additive. We see the effects of these public health measures every day in our work. We see the effects of cigarettes, alcohol, vaping, sugar, and every patient that comes through our operating room. Even worse is the potential for the bill to enable individuals or companies to seek compensation for the government for lost profits if legislation to prevent harm and improve public health were introduced. In summary, the college does not support the bill because we believe it to be unnecessary, costly, and a grave risk to our health. Thank you.
Thank you for your submission. We've got about 2 minutes left. I'm going to go first to Mark Cameron.
Morning, team. Sorry for my attire. I'm on farm and stuck away from Wellington. Thank you, Rachel and Brendan, for coming in this morning. I've written down a few figures on my piece of paper in front of me, and it's $32 billion. Do you know what that is in reference to in terms of the Ministry of Health?
Sorry, then can you repeat that?
The figure is $32 billion. I was just trying to ascertain whether you good people were aware that that is the cost to run the Ministry of Health a year. Now, it used to be $18 billion 5 years ago. Would you argue productivity in terms of the Ministry of Health has improved or declined?
I'm not sure I'd be able to make a comment on that in my...
Okay, that's fine. That's fine. I appreciate your rather difficult and tenuous position. The reason I ask that, it has grown significantly in 5 or 6 years, the cost to the Crown. The reason, this is a question as much as a statement, do you believe that a regulatory standards bill that is premised on reducing waste inside the bureaucracy of Wellington would improve health outcomes if we could actually afford more to go towards the Ministry of Health, not less? Do you think that would improve outcomes based on the $32 billion we currently spend in health?
I think it's dependent on where that money would go. You know, it's easy to say if we get more money for the Ministry of Health that it would, give us more of anything. But what will it give us more of? It's pretty evident within healthcare at the moment. There's a lot of money being spent on things outside of specific medical practice management, etc. And it's hard to say that money's providing better healthcare for New Zealanders, particularly given that we're short on a lot of things within the health system overall.
And if I may, just very quickly touch on your point. So evidently what you've highlighted is waste. Do you agree then, based on that statement or poor investment, that the Regulatory Standards Bill, based on its premise, is to reduce waste?
That's not how I read it. Like, I understand that that's the summary of how it's being presented to us, but reading through the bill, I'm not sure that that's the effect it would have.
Thank you. No further questions.
Okay, we've met time. Thank you for your submission, ANZCA. Appreciate that. We're now going to move to Sir Geoffrey Palmer, who I can see is looks like in the flesh in the select committee room. Sir, you will know the process well. You've only got 5 minutes as it's a personal submission, so I'm sure there'll be people that will want to ask you a little bit of question at the end. In your hands.
Thank you, Chair, and thank you, the committee, for giving me this opportunity. In a long career as a constitutional lawyer here, in many different capacities, as an MP, as a law professor, as president of the Law Commission, this is the strangest piece of New Zealand legislation I have ever seen, and it is quite bizarre. And it will not work. There is no chance of it working because it has as its encompass the entire regulatory mechanism of 1,100 statutes, plus all the secondary legislation that is made under it. And that is an impossible brief. And the idea that anything good could come from it is idle. Now, the thing is that the bill is going to be divisive in this community, and it is going to reduce the trust of New Zealanders in their parliament and damage their sense of democratic cohesion. The thrust of the bill is based on an unproven ideology that New Zealand has too much regulation now. That is asserted, but it is not, no evidence is provided to support it. I further suggest that the proposal as it stands is constitutionally unsound. It is constitutionally unsound because, as one of its strange characteristics, it says that this statute is law for some purposes, but not for others. And how can it be that you have a statute that is like that? I have never seen that before. And the purpose of it seems to be either to avoid scrutiny through the courts or to avoid proper scrutiny at this committee. Either way, it is disreputable. And this is not the way to make law. Now, the proposal is also going to disrupt the working of the House of Representatives. Indeed, it is designed to do that. The Regulations Standards Council is going to drop reports like leaves in autumn over all sorts of ministers, select committees and everything, saying, how do you justify this regulation? Now, that is a disruption. It is designed as a disruption on ministerial responsibility, which goes on every day in the House of Representatives. What it does is to split ministerial responsibility, and that is going to make the conduct of ministers in the Parliament very difficult. They must take responsibility for statutory regulations that are made under the authority of the Acts in their portfolio, and this is going to produce a terrific amount of extra work. And over the long term, it is designed to reduce the amount of regulation, when in fact regulation is necessary in many ways. I remember as a young lawyer working on the children's night clothes regulations, where if children got near heaters, their night clothes burnt them. Obviously, there are many things like that where regulation is absolutely necessary. And the idea that somehow you would not allow the Parliament to protect the public of New Zealand from dangerous things is just risible. Now, the correct approach to this is to follow what the officials say. The minister's own officials oppose this bill, and they are right to do so, because what they say is there's another and better way of doing it. We have a Regulations Review Committee, which has been active for many years. It was set up in my time as Deputy Prime Minister. We have a Regulations Disallowance Act, which is under the Legislation Act 2019. The Regulations Review Committee conducts hearings on regulations all the time. It is better to use what the regulatory impact statement says, and it's a very good one, that you implement Part 4 of the 2019 legislation, and you use the Regulations Review Committee to test whether this unproven proposition that we're over-regulated is correct. The Regulations Review Committee has been looking at these matters for years and years. They report to the Parliament all the time. They are, by convention, chaired by an opposition member. That is entirely neglected in the design that went on. They've just ignored that. Why don't they examine the existing material and try and use it better? That would be the way to fix this bill, because this bill needs a lot of fixing. It is fundamentally objectionable. And I think that the disallowance procedures that the House already has, they can disallow any regulation virtually they want. They can do it on a motion. The Regulations Review Committee has power to, the special members, sometimes regulations has even been disallowed because it went over time, they never got to vote on it in the House. Now, I don't think there is much knowledge shown in the design of this legislation that is at all sound or thorough, and I deplore that casual approach to lawmaking. Thank you.
Thank you, Sir Jeff. We have actually gone over time, unless have you got a quick one, or are you happy to carry it over?
It's not a quick one.
Okay, we'll leave it there. Thank you, sir, for your submission. We're now going to move to Cooper Legal IP. Thank you, presenters. We have you for 10 minutes. And again, I just encourage you to save some time at the end, because as you can see, it goes very quickly.
It does. Yeah, tēnā koutou, so Sonia Cooper and Rose Peoples from Cooper Legal. For those who don't know, Cooper Legal is a law firm which represents clients who suffered abuse while they were children in state and or faith-based care. We've been doing this work for over 30 years, and throughout those years, we've represented thousands of survivors of abuse. Today, we're here to speak on their behalf, here to advocate for their needs and to stress their hope and plea that the government does not allow one more child to endure the abuse they suffered. Just last year in November, the Prime Minister stood up and on behalf of the government apologised to survivors of abuse and care. He said it's on all of us to do all we can to ensure that abuse should never have been accepted, no longer occurs. This bill, which purports to dictate what good lawmaking is for all current and future law, is not going to provide that certainty. It is not even close to doing so, and in fact, may in our view facilitate a statutory and regulatory framework in which abuse continues to occur. At best, this bill will be a waste of time and money, a pointless regulatory hoop to jump through. From our perspective, it is insulting to waste time and money on this legislation when so many individuals, academics, and organisations are asking the government to devote its resources towards, among other things, looking after those who are in need. This has been a fundamental tenet of New Zealand policy making for decades. Just giving an example, just last week, the official Understanding Reports of Concern paper published on Oranga Tamariki's website detailed the critical underfunding of Oranga Tamariki caused by job losses there and drastic cuts to community agencies that have been providing services to vulnerable children and their whānau. The report highlighted that there is a 95% plus chance that children could suffer injury or illness with disabling effects, and Oranga Tamariki will not be able to deal adequately with tips coming in about children at risk over the next year or two. And this is just the best case scenario. What we believe and fear will actually come to pass is much grimmer. This is a poorly thought out bill. It sets a requirement for good lawmaking without seeming to have any sense about what a thriving society requires. It is unacceptable to make a claim that any lawmaking is good when it prioritises economic efficiency at the expense of the well-being of people, when it insists on a strict equality, which will actually heighten inequalities, when it ignores Te Tiriti, the founding document of our nation, and it ignores environmental concerns as well as New Zealand's international obligations. We are concerned with the principle, every person is equal before the law. Often we need laws which are designed to distinguish between people in order to protect those who are recognised as being particularly vulnerable to exploitation and discrimination. Our clients, who are survivors of abuse and care, have a very distinct and urgent set of needs which cannot be properly recognised if they are treated as being equal to everyone else. Abused, traumatised, and institutionalised as children, they now need the state to provide services and design policies specific to their needs, because they are not and have not been able to exercise their rights before the law in the same ways that others are and have been able to. In the context of our work with survivors of abuse and care, we are very aware of the disproportionate harm Māori have suffered. This bill, with its blatant disregard of Te Tiriti, and refusal to accept the need for policies which may need to treat people differently in order to achieve equity is an act of discrimination against Māori and will further the many harms we see on a daily basis. We are concerned about the implications of the takings principle. In order to be compliant with the takings principle, any legislation or regulations governing the provision of redress by non-state organisations to survivors would need to provide, in the theory, for those organisations to be compensated for the impairment to their property. Further, this compensation may need to be provided by the very survivors who are receiving redress, because they are obtaining the benefit of the impairment by receiving that redress. It should go without saying that any such regime is nonsensical. Survivors of state and faith-based care have long been advocating for a comprehensive redress system, which would be unlikely to pass the threshold set out by the bill. This would be a great detriment to survivors of abuse who need and deserve a proper system of redress that adequately acknowledges the harm they've suffered and continue to suffer. We would hope that any proposed legislation that aims to protect our children from harm or provide redistributive justice to survivors of abuse would be considered justifiably inconsistent with the principles set out in the bill and would pass into law, notwithstanding the barriers passed by the bill. But this could not be guaranteed. The idea of what constitutes good lawmaking processes and principles is complex and multifaceted. Figuring this out is an exercise that we have undertaken as a society over millennia. If we are adamant that this needs to be defined in statute, this bill's approach is not the right one. If laws which aim to promote our collective aims as a society to keep our children safe and properly redress the rights of those who we've failed to keep safe are inconsistent with supposed good lawmaking principles in the bill, then we have not put the right principles into the bill. We conclude by going back to what we started with. The Prime Minister made two promises during his apology to survivors. First, we must do the right thing by you and provide you with the support you need. And second, we must do all we can to prevent abuse happening in the future. The Regulatory Standards Bill does neither of these things. Passing it into a law would be a breaking of these solemn promises. We urge this committee to strongly recommend that the bill is not passed into law. We agree with and support the submission of the New Zealand Law Society and others who are making similar submissions.
Okay, thank you. Sorry, my screen just froze at the end, so I wasn't sure if there was another statement coming. We'll go now to Dr. Deborah Russell.
Thank you very much for your submission this morning. It's a delight to see the Nicomachean ethics being quoted in a submission. Really appreciate that. So this is in paragraph 18 of your submission, and you talk about the distribution of goods being achieved by proportional equality. Damien O'Connor once said to me that in our law, we don't legislate for the centre, we legislate for the marginalised cases and for the margins of the people who are at risk. Do you see this particular piece of legislation as reflecting that kind of approach to lawmaking?
No, I don't. I think it's potentially the opposite to that. I think, as we've said, to make the statement that everyone should be equal before the law could achieve the opposite of that. There is a need for legislation in New Zealand, and that's always been reflected, that you need to prioritise those who are discriminated and whose well-being are not necessarily well protected by the law by passing specific law. I mean, the Human Rights Act is a good example of that. The Bill of Rights Act is another good example of that. There is a lot of legislation in New Zealand and regulations that follow from that are to make sure that those who are marginalised and who otherwise are in the most vulnerable sectors of society have protections from the law, and I think that has been a fundamental tenet of New Zealand law. Right from the beginning of the 40s of our welfare system, is that we have as a society always had that obligation and that understanding that we need to look after those who are more vulnerable and who actually don't have access to justice because they don't know how to access justice. I mean, there's a great deal of research that shows that the particularly vulnerable have multiple legal needs, but their ability to actually access that is very limited. So I think this bill potentially would achieve the opposite of that.
Thank you.
Thank you, Deborah. Have you got a quick one, Mark?
Yes, really quickly, if I may. Thank you very much for your submission this morning. So just for clarification, you are saying to the committee, if I may, that you maintain that human beings are created equal, but law should be different by way of appropriation based on that need. So they're created equal, but they're not treated equally. Is that the clarification that you're offering this committee today?
Well, that is the way that society operates. I don't think that is a fact, is that some people are marginalised, that while people are born equal, in fact, they're not born equal. I mean, a lot of New Zealanders are born into poverty. A lot of New Zealanders are born into a context where they don't have enough to eat, they don't have warmth, they don't have security. So, I mean, it's a nice thought that everybody's born equal, but that's not the reality.
So if I may, I don't mean to interrupt you. So what you're inferring is that certain people have certain rights and duties and others have different rights and duties in New Zealand's constitutional framework. Is that correct?
What I'm saying is that those who are particularly vulnerable and marginalised need special protection from the law. And we have plenty of legislation that has done and has always done that. I mean, as I say, the Human Rights Act is a very good example of that. Many of the international conventions to which New Zealand is a signatory party recognises those forms of discrimination, racism, and that is why we need to have special laws that acknowledge those and protect those rights because of that vulnerability and because not all people are treated equally before the law or in the way that society deals with them.
So very quickly, if I may, just to follow on from that, in the case of victimhoods and those that are presented to court in a defensible position, do you think they should be treated equally or differently?
What's your question?
In regards to victims of crime and how they are afforded, in the eyes of the law, equal justice before the law, should they be treated equally or differently?
Equally with whom?
Well, I think the question is like, when someone goes to court, should they be afforded equal justice before the law in terms of a defence? We have a system that requires that any crime is proven beyond reasonable doubt. That is our criminal justice system. That's been long-standing.
I think we'll leave it there. Sorry, Mark, we're just drifting and we are a bit over time. Thank you for your submission, Sophie and Rose. We're now going to go to Ngā Iwi or Taranaki. I see Dion waiting there online. Kia ora and welcome. You've got 10 minutes. Encourage you to speak less than that to allow some time for some Q&A.
Nā koutou, whare o ka wano taku ingoa. Pai whakahari, I'm the CEO for Te Tōpuni Ngā Rahu Ngā Iwi o Taranaki, which is our collective of 8 iwi here in Taranaki. I've got Dion Luke, our principal planner, here with us. Liana Potu, our chair, is not had a bereavement within the family, so she's not available today. So we represent Ngā Iwi o Taranaki, which is the 8 iwi around our maunga in our region. We're all each of the 8 iwi have settled claims and established government and operation bodies as post-settlement government entities, PSGEs. Those iwi are Ngā Rauru, Ngā Ruahine, Ngāti Maru, Ngāti Mutunga, Ngāti Ruanui, Ngāti Tama, Taranaki Iwi and Te Aotearoa. And we here oppose the passing of this bill into law. Each of the iwi have also put in submissions opposing, and they have but we have this collective body that we speak on behalf of at this point. Our response stems from our responsibility to advocate for the rights and interests of the 8 PSGs in our region. Each iwi, as I said, has concluded the settlement of historic claims for breaches of te tiriti over a period of 20 years. We note within the Settlement Act for these historic claims against breaches of the treaty contain a Crown apology that state the Crown seeks to atone for these wrongs. The Crown seeks being part of the process of healing with settlement. The Crown looks forward to building a relationship of mutual trust, cooperation and respect for treaty and its principles. The coalition government agreement makes it clear that the coalition government has no intention of maintaining the honour of the Crown. The honour is set out in our Treaty Settlement Acts and the principles of Te Tiriti as developed over decades of constitutional and convention and common law of Aotearoa, New Zealand. This is confirmed by the placing of the principles of Te Tiriti outside of the scope of what would be covered by the Regulatory Standards Bill. Now, Iwi will provide some background to the discussion then provide our response to the documented questions, and I'll pass over to Dion to take us through that process. Kia ora.
Morena ina memo te committee. So we'll take the written submission as read. We'll just focus briefly on some main points. So we'll look to start with the principles of responsible regulation and regulatory stewardship proposed by the bill reflect the narrow real view of this government. Rather than improve regulatory stewardship and lawmaking, these principles will enable ongoing irresponsible government based on corporate principles. So the Ministry for Regulation has consistently maintained its preferred approach to implement the government's policy is to enhance the disclosure statement regime. This will achieve many of the benefits the policy intends to establish while imposing fewer compliance costs on government agencies. That the Minister for Regulation has ignored this expert advice from his own agency is telling, but unfortunately predictable. We acknowledge the courage and professionalism shown by the Ministry for Regulation staff in the climate of fear and insecurity that this government has created. Noting the departing Auditor General John Ryan's comments, that officials should never feel that they are walking on eggshells when giving advice ministers do not want to hear. This bill would duplicate existing regulatory management systems which are not being used responsibly by the government in the first place. The cost and effectiveness of the proposed changes are unknown. The impacts of the proposed bill have been assessed by the Ministry for the Regulation. Unfortunately, both the financial costs and options for providing for Treaty of Waitangi have been heavily redacted on the basis of legal privilege. We note with concern Cabinet's process to approve the drafting of this bill was deliberately timed to remove the Waitangi Tribunal's jurisdiction. Had the Tribunal not moved its urgent hearing into the proposed bill forward in response to Cabinet's actions, there would have been no ability for the Tribunal to conduct the necessary inquiry. Despite this, the Tribunal has managed to produce an interim report finding that the lack of targeted and meaningful Crown engagement with Māori on this bill is a breach of the treaty principle of partnership and its obligations to consult with Māori in good faith. Similarly, if the Crown were to enact the Regulatory Standards Act without meaningful consultation, it would also breach those same principles. The contempt shown for the Waitangi Tribunal and the redaction of taxpayer-funded impact analysis are not missteps, they are deliberate attempts at obfuscation. We unconditionally support the Waitangi Tribunal's recommendations that the Crown immediately halt the advancement of the Regulatory Standards Bill and that the Crown instead engage in good faith consultation with Māori on options to improve regulatory standards. The bill prioritises corporate property rights and economic interest over public good and environmental safeguards. This is significant given iwi, hapu and wānau have kaitiakitanga obligations to protect their awa, whenua and moana for future generations. If the bill is to progress, it must explicitly include Te Tiriti o Waitangi as a paramount principle that is given higher legal weighting than other principles. And it must also prioritise environmental protection, acknowledging the undisputable role iwi, hapu and wānau play as kaitiaki. The committee, thank you for your time. I'm happy to answer any questions.
Thank you. I'll go to Debbie Ngā Rewa Peka.
Tūtahi ngā mihi kia koro e te whanaunga. My partai through the chair is, do you believe that this bill has the potential to unwind both your own existing treaty settlement arrangements and the entire redress system more broadly?
Tēnā koe te tuaine me te awatanga ki tō tātai tuaine ia Tash. It's huge concerns, not only from us here in Taranaki, but Iwi across the motu. But here we speak on behalf of our Iwi here in Taranaki. Huge concerns. We've just recently settled our Maunga bill, of course, and we've gone through a whole process that's been 20, 30 years, as you'll know, tuaine. And for us to be at this point, we have huge concerns on this bill, and it will most certainly take us back to a place that we've been, and we've achieved so much through this period as 8 PSGs that are settled, along with our maunga.
Thank you, Dr. Deborah Russell.
Oh, kia ora. Just going to note for the record, I'm Taranaki born and bred and love the maunga. Look, there's one short sentence in your submission at paragraph 20, and I was just wanting to elicit a little more comment from you, if you would. And it says very straightforwardly, those principles, it's in clause 8, also assume that the environment possesses no rights or liberties. Are you able to just expand on that just a little and some of the issues you see there?
So it's focused on individual private property rights. Obviously, there's at least 3 treaty settlements which refer to the rights of the environment, Te Wera Act, Te Awa Tupua, and now more recently the collective redress for Taranaki Maunga. So that clearly outlines that the environment does have rights. It's up to those responsible to speak for that part of the environment and the various aspects that connect people to that environment. So, yeah, it's a very narrow focus on individual private property without recognising and acknowledging the rights of the environment.
Okay, thank you.
Thank you. That looks like the end of our questions. Thank you, gentlemen, for your submission. I really appreciate that. We are now going to move to Po Tangata National Iwi Chairs Forum.
E te tia mana tēnei te mihi atu kia koe me tō komiti. O tira, e mihi ana kia koutou e whai wāhine a hau ki te kōrero kia koutou. Mr. Chair, thank you for the opportunity to put our submission and to further some of the discussions. I do want to at this point acknowledge the recent passing of Takutai, the MP for Tāmaki Makaurau. Mr. Chair, I'm going to take our written submission as read, and just to implore on you that the Po Tangata is one of the 5 Po of the National Iwi Chairs Forum, who represents more than 80 chairs across the country. Just recently, we had our hui in Tūranga in Gisborne, and so a lot of the discussions here have been derived from there. I can confirm, Mr. Chair, that contrary to popular view, this is not a bot submission, that this is actually in the hearts and minds of people that have been talking to us as the Po Tangata. Mr. Chair, but of major concern. So right at the get-go, we are in opposition of this bill going forward. We call on the committee to show leadership in stopping this bill until there can be fulsome and comprehensive consultation. And so that's one of the major points. The major point is the sidelining of Te Tiriti o Waitangi and the lack of consultation around that. We say that actually this is poor form for a government piece of legislation going forward, where Te Tiriti has actively and purposefully been sidelined and not even taken into consideration. I note in Section 8 with the principles that actually Te Tiriti o Waitangi doesn't feature. With the recent voting down of the Tiriti Principles Bill, we think that this is a relitigation of the Treaty Principles Bill under another korowai, under another cover. And so we say the attacks keep on coming. Mr. Chair, we think that this bill is actually servicing the few and ignoring the many. We think that this is about individual property rights as opposed to the collective property rights that Māori have at the core function of ourselves. We think that this is about money over manakitanga. Manakitanga of communities, including Māori and our diverse communities out there across the country. We think that this is all about economic gain. We think that this is all about money over manakitanga. We think that this is a degradation of settlement legislation. Earlier in the term of this coalition government, they made some promises that settlement legislation would be sacrosanct and that they wouldn't meddle with those pieces of legislation. This is actually in contrary to the declarations that were made by all three coalition parties and as part of the coalition deals. We think that there are clear examples of pieces of legislation that recognise the environment that are seeking to be minimised here in this RSB. We think that there are provisions and mechanisms within settlement legislation that are actively being pushed away and pushed aside. And so we expect that the coalition partners will live up and to exercise the obligations and the responsibilities that they have espoused over the last wee while. We want to put our attention really to the discrimination and racism aspects that are flowing from this particular bill. We think that there is already discrimination, that there is always an air of racism happening here, particularly to the detriment of Māori and to the detriment of our Pacifica cousins that live in Aotearoa, New Zealand. And we think that this is an opportunity. The RSB, should it go through, is an opportunity to really double down on that discrimination and that racism. And we think that the committee should be making recommendations to stop that until there is fulsome and comprehensive consultation with input from all communities around here. I note on that point that in 2024, according to the Electoral Commission, 88% of submitters for the RSB opposed the principles and the pieces of legislation in here. So I'm calling on the committee to take the pulse of the people and say, "Tai hoa, hold this up. Don't even go forward with this until there is something comprehensive that we can do." Mr. Chair, in our humble view, this, in our view, is a power grab. This is a power grab into the hands of the few. This is a power grab that will support the old boys network. That just because the voter base of smaller parties are coming in full support of this, we think that this is the RSB bill will be able to support actually not a clear process within Aotearoa, but it will be a unilateral process by ministers and ministries that will have a veto, the power of veto over any pieces of legislation going forward from here. So this is a power grab that supports all of those, the few that have benefit of the misery of Māori, and going forward, we say, actually, whakahokia te mana ki ngā ringaringa o te iwi. Give back the authority and control into the hands of the people. And so when politicians talk about democracy, then that should be upheld. And Mr. Chair, again, thank you for the opportunity. The Pou Tangata for the National Iwi Chairs Forum is absolutely in opposition to the continuation of this bill.
Kia ora, thanks, Rahui. I always enjoy your kōrero, regardless of what platform you speak on. You do it with much conviction. Debbie Ngārewa Packer.
Tēnā koe te rangatira. Through the chair, my question is that if this mechanism within the RSB as proposed is used to challenge laws that provide for Māori rights and interests, how will this affect the work of the Pou tangata in the National Iwi Chairs Forum?
It will actually exacerbate the problem. So at the moment, there are discriminatory things that are already out there. This has the opportunity to double down on those. This has the opportunity to exacerbate all of those. So the poverty of our people will increase. The unnatural statistics that Māori face in the social sector will bubble over almost into a crisis. And so at the moment, there are comprehensive work programs happening now. This RSB will seek to redesign what is already happening and veto what will be going into the future. So it will be absolutely detrimental, in my view, to Māori and communities across this country.
Good. Thank you, Mark Cameron.
Rahui, sir, it's lovely to see you here this morning. I note, obviously, the Regulatory Standards Bill as its intentions is try and alleviate, as in my view of the world, the cost and duplication that we see in government. On that, if that is the intent of the bill and the way some people view it, do you agree that in terms of the settlement process, sir, that all parties have agreed to all settlements, that Maori and New Zealanders in general should reap the benefits of a less bureaucratic system in Wellington? In other words, that settlements would be faster, that outcomes for Māori would be better based on the reduced waste that quite often is found in Wellington. Would you see that correlation?
You're talking about a perfect world, Mark, and kanui te mihi kia koe. Look, when we talk about a perfect world, of course, but the flow-on effects of this have the opportunity to do exactly the opposite. When we're talking about streamlining the efficiencies within Wellington, that's always going to be something that we must consider. But when you streamline so much that actually the progress in the process, like, for example, the collapsing of Te Arawhiti has actually made the process slower. And so, whilst we're looking for efficiencies, whilst we're looking for equality, we need to measure that with the equality for whom and the speed in which we can get some stuff done. So if we're talking about expediting sort of settlement processes, then this has the opportunity to do exactly the opposite.
Thank you, sir. Thank you for your time.
Thank you, Rahi. I really appreciate your time. Rahui, ka kite te ano. Okay, we're now up to Te Hunga Roia Māori o Aotearoa with Natalie presenting.
Tēnā koe te tiamana o tērā koutou. So my name's Natalie Coates, and I should be appearing alongside my colleague Tai Ahu, who I understand should be on the line, so hopefully he can be beamed in as well. But I'll start. So we're kautumuaki of Te Hunga Roia Māori, or the Māori Law Society. The summary of our position as a hunga is that we oppose the Regulatory Standards Bill in its entirety. In summary, we think it needs to be thrown in the bin, or at the very least gutted and completely rebuilt from scratch. The bill proposes a significant and fundamental constitutional shift in how laws are, of course, made, justified and reviewed in Aotearoa, New Zealand, and it proposes to anchor our laws, both current and future, to a narrow set of principles that do not originate in public consensus but infringe libertarian thought. So in summary, this bill is constitutionally unsound, flagrantly breaches and ignores Te Tiriti o Waitangi, prioritises contested neoliberal values and elevates economic liberty above collective well-being, and if passed would of course proceed despite significant public opposition and against official advice. That is not good lawmaking built with the whole country in mind. It is a minor party pushing their political waka against the tide, blind to the current beneath. Strengthening our regulatory system is, of course, a good aim, but the bill as currently framed doesn't do that, and in fact would destabilise it, privileging some interests, sidelining others that have been long-standing legal tradition in Aotearoa. So we encourage everybody in this committee, but in particular those from New Zealand First and the National Party, to not toe the ACT Party line on this particular kaupapa, but to stand for constitutional and regulatory integrity and what that demands. So I'm going to speak to two particular issues, and then I'm going to hand it over to my colleague. The first, of course, and I think other people have mentioned this, is the deliberate exclusion of Te Tiriti o Waitangi from this piece of legislation. Te Tiriti has, of course, been a long part of New Zealand's constitutional architecture. Its consideration is required by the Cabinet Manual, legislative drafting guidelines, and decades of legislative practice under both the Labour and the national governments. To exclude Te Tiriti from the very definition of what good lawmaking is to redraw constitutional boundaries in a way that removes the partnership that the Crown agreed to uphold and is a contradiction in terms. Te Tiriti is not something that can or should be unstitched from lawmaking. It's part of the thread that forms our constitutional fabric in Aotearoa. Its absence isn't, of course, a drafting oversight, but a deliberate omission that bucks a clear break from constitutional best practice and our treaty obligations. Let us be clear on our position, though. We point out its absence, not to say that simply adding a treaty clause in would fix the fundamental problems enshrined and evident in this bill. The second point I wanted to briefly chat to or talk about was that the principles that this bill seeks to enshrine come from a very specific economic school of thought, one that prioritises individual property rights and deregulation. They were, of course, advanced in the 2009 ACT Party-led task force and have been rejected by Parliament multiple times for very good reason. Yet here, we're proposing to elevate these principles through statutory force to the level of constitutional norms. That is not how we should embed constitutional values intended to span democratic cycles into our lawmaking culture. We do not have time to go through all of our concerns with each of the proposed principles and their practical implication. That's hopefully evident or at least summarised in our submissions. But just to take two briefly, the rule of law. As lawyers, we uphold the rule of law, but as defined here as simply equality before the law is narrow and concerning given how this government thus far has interpreted the idea of equality and could therefore be weaponised. Secondly, individual property protections. Property rights are already largely protected in Aotearoa, but it's offensive to prioritise these as a key regulatory po in a context where Māori property rights have been overwhelmingly disrespected over time, including mass confiscations, not only historically, but continue to be now. So, for example, Māori rights in the Takutai Moana are the only property rights specifically excluded from the property protections under this bill. So we'll protect property rights, just not the long-standing Māori ones. So it's not only what this bill includes, but also what it excludes as well. It's like building a whare with all these key po missing. There are no parallel protections for collective Māori rights, tikanga Māori, environmental well-being, and the like, even though these values are at the heart of not only many New Zealanders, but also our contemporary regulatory frameworks. So I'm going to hand it over to Tai to conclude our submissions.
Tēnā koe te tiamana, Ryan. O tira koutou ngā memo o te komiti. I want to speak to a few additional points and follow on from the submissions of my colleague, because we've heard the argument that the bill is about improving efficiency, but as Jeffrey Palmer had pointed out, having to assess almost every future bill or regulation against a very selective set of principles does not create efficiency, it does the opposite. The bill makes lawmaking inefficient. It fails to recognise the range of reasons for which we need regulations and places our lawmaking process into a straitjacket of neoliberal political theory. Also, we've seen what happens when regulation is made weak. It creates inefficiency and increases the cost to taxpayers over the long term. And examples we can think about are the leaky buildings saga, financial collapses that are caused by the failure to regulate lending practices, which have only exacerbated and widened existing health and social inequalities. And this bill, I think, will potentially exacerbate those. We do know that good regulation can improve outcomes in health and housing and employment and also in the environment. But in our submission, this bill does not do that. It risks producing more harm than benefit, especially for communities carrying a structural disadvantage. In terms of Māori, the risks of this bill are serious and disproportionate, and that point was made by my friend Natalie. I guess well-resourced actors could potentially challenge tiriti-aligned regulation or kaupapa Māori initiatives as being inconsistent with the bill's narrowly framed principles, even when such initiatives are delivering on equity, partnership goals, as well as te tiriti o Waitangi obligations of the Crown. Māori entities operating in health and in the environmental space and governance spaces could become entangled in legal challenges, procedural risk, or financial exposure simply for participating in the state frameworks as they currently exist, and that point was made by Rahui. If this bill were in place 50 years ago, I would hate to think what it would have said no to in terms of the range of legislative protections that were designed to reflect the tiriti o Waitangi, address inequalities and level the playing field. Furthermore, the bill doesn't stack up. It doesn't achieve its stated objectives. It aims to promote accountability of executive to Parliament, but whose accountability? It aims to increase transparency and support scrutiny of bills, but for Māori it does the opposite. Ignoring the treaty makes the executive less accountable and less transparent about Māori rights and interests that are managed at a local and national or government level. Also, the bill has a harmful ripple effect because it sends a signal to public servants that the impact of regulations and laws on Māori are not important. It supports ignorance towards Māori in lawmaking and risks taking race relations backwards. So in conclusion, our submission is that the bill does not promote good lawmaking. It promotes ideological entrenchment, constitutional imbalance and risk for Māori. It excludes te tiriti, bypasses proper consultation and embeds a set of principles that were never really built for Aotearoa's unique legal, cultural and constitutional context. We submit that this bill should go no further, and we respectfully call on National and New Zealand First, who refused to support the Treaty of Waitangi Principles Bill, to refuse to support this bill for the same reasons. It creates division at a time when we need unity. The waka of lawmaking must carry us all, not just those with the loudest voices or the deepest pockets. Nō reira, kei ngā me mō te komiti, tēnei te mihi kia koutou.
Kia ora. Thank you, Ty and Natalie, for your submission. We're just about at time and there don't appear to be any questions, so I think we'll leave it there. Ka kite anō korua. We're now going to go to Sophie Bond. Sophie, if you're there, this is a personal submission, so it's just 5 minutes, and I encourage you to leave a minute or two at the end for questions. Welcome, Sophie. Sorry, did you hear me just then?
I did, thank you, yes.
Oh, perfect. In your hands.
Kia ora. I'm an associate professor in the School of Geography at the University of Otago with expertise in political geography, environmental management, and specific expertise in climate change, adaptation, community engagement, local governance, and community responses to environmental change. I oppose this bill in its entirety for several reasons. In summary, it's unnecessary, as the advice has stated itself. The government has no mandate. My second point, it's an initiative of the ACT Party, clearly reflects ACT Party values and ideology. ACT secured only 8.6% of the vote, and given the constitutional significance of the bill, the Prime Minister made a significant error in agreeing to it as part of the coalition agreement. He gave a minority party a disproportionate amount of power, so it's undemocratic. It undermines the proportionality principle inherent in our electoral system. The bill creates itself, my third point, the bill creates itself as a kind of regulatory constitution, as many experts will have noted in their submissions already. It will establish itself, or the bill will establish itself as a superior piece of legislation over others that will determine how legislation is enacted and provide this means to evaluate existing legislation. In doing so, it will constrain future governments, unless, of course, they repeal it, and undermines past governments by being retrospective. The mechanism for assessing regulation puts far too much power in one minister, and ministry, who is also responsible for electing the board. My fourth point, the bill's principles for responsible regulation are narrowly construed and reflect libertarian values, which are not those of the 91% of New Zealanders who did not vote for ACT. And there are several problems with these principles. One, the rule of law is complex and contested, legal doctrine that should not be codified. Two, equality before the law has been qualified and superseded by important recognition that treating some groups unequally is morally right and provides better equality of outcome. Three, several terms are vague and imprecise and will be difficult to apply. Four, the liberties principle prioritises individuals and private property at the expense of collective good and common properties such as air, water, conservation, estate, and so on. And these will constrain government's ability to legislate for the public good. For example, in relation to climate change adaptation, it's clear and has been well established by research that legislation is needed to provide local government with the relevant mandate and planning tools to manage land use changes that are necessary for areas that are impacted by climate change in the future, such as areas affected by sea level rise and increased flooding. So this bill will constrain the kind of innovative responses that are needed to respond collectively to future challenges at central and local levels, provide clarity for property owners, and prevent local government from being proactive and respond fairly in the face of changing climate. Regulation has a really important role for incentivising collectively desirable behaviour that makes living together in the contemporary world much fairer, more just and more equitable, protecting future generations and the planet. And the bill will not facilitate the development of this kind of legislation that's crucially needed. My fifth point, the lack of reference to Te Tiriti o Waitangi, as previous submitters that I've just heard have stated, reflects a fundamental breach of the spirit, intent and text of Te Tiriti. The treaty is part of the normative dimensions of Aotearoa New Zealand's constitution and defines our identity as a nation. The bill breaches at least 5 treaty principles, and I support the submission of Dr. Carwyn Jones and others who have noted this, as well as the findings of the Waitangi Tribunal on their urgent hearing. Finally, there's a high degree of hypocrisy embedded within the process that this bill has followed that provides a clear insight as to its real intent, which is to embed ACT's libertarian ideology at a constitutional level. The bill would not withstand an evaluation under even its own narrow terms. It's ill-conceived, poorly drafted and undemocratic. The process has lacked transparency, has not engaged with stakeholders, specifically Māori. It has been pushed through too fast and has frequently been misrepresented as to its true impact. This all speaks to the fact that it is a dangerous and ideologically driven piece of legislation that should never have been agreed to and agreed to in a coalition agreement, given its constitutional implications. So I oppose the bill in its entirety. Thank you.
Thank you, Sophie. We're just about at time, so unfortunately we're going to not be able to take question. Thank you for your submission. Sorry, Megan, I hope to come back to you on the next one if we've got time. We're now going to go to Asians Supporting Tino Rangatiratanga, and I believe we've got Kirsty presenting. Welcome, Kirsty. We've got you for 10 minutes as an organisation, but encourage you to leave some time at the end for questions.
Well done. Tēnā koutou. My name is Kirsty Fong. I am speaking on behalf of Asians Supporting Tino Rangatiratanga, a national organisation of tau iwi from diverse backgrounds who support the rightful restoration of Māori mana motuhake and Tino Rangatiratanga. We start our submission on the indisputable fact that Māori have never ceded sovereignty, and we are here to express our collective and unequivocal opposition to the Regulatory Standards Bill and urge that it be rejected in its entirety. We take our written submission as read. Many in our communities have either migrated or have been displaced by colonisation and imperialism. Our experiences and struggles intersect through racialisation, gender discrimination, economic justice, injustice, and we are deeply concerned about how this bill will worsen these existing injustices. The consent for us to be here is through Te Tiriti o Waitangi. This is the sacred agreement that provides a framework for how we live together in right relationship. By omission, this bill is another attempt at erasing and diminishing the importance of Te Tiriti. As the claimants to the Waitangi Tribunal have stated, the process and content of the RSB is a direct violation of Te Tiriti o Waitangi, as is the blatant disregard of any consultation with Māori and affected groups. As the Waitangi Tribunal has found, the bill is in breach of Te Tiriti and must be halted immediately. Instead of centering corporate interests, we are instead guided by the values already articulated in Mātike Mai Aotearoa, inclusive and caring values such as belonging, conciliation, tikanga, and interdependence in a shared future. We are concerned that the specific services that seek to alleviate unequal and inequitable outcomes for different groups of people will likely be eroded under the RSB. We live intersectional lives. The experiences of racism, language and economic barriers, gendered violence, ableism, Islamophobia, homophobia, transphobia, precarious and exploitative working conditions. Services like ethnic and migrant health programs, specific support, rainbow services, disability services, refugee resettlement resources are all vulnerable under a deregulation framework that values only short-term economic profit and return. We have already seen what happens when public services are measured by profit alone, and under urgency the government disestablished the Māori Health Authority Te Aka Whaiora for the sake of efficiency, despite warnings that this would worsen Māori health outcomes. We are lucky to be connected to networks of tau iwi of diverse migrant and refugee backgrounds who are out there educating our own communities. Every week there are treaty workshops delivered in different languages, Urdu, Swahili, Mandarin, Korean, Arabic, and this is driven from within communities because we understand what it means to be guests on someone else's land. Collectively, across generations and communities, we are aligning with tangata whenua. We are seeing through the colonial myths and propaganda that would like us to believe that Māori are the problem. But we see through that, we see that the Crown is the problem, the violations of Te Tiriti is the problem, ongoing colonisation is the problem, white supremacy is the problem. The Regulatory Standards Bill is just another symptom of the underlying problems. The RSB aims to embed the ACT Party values and principles that are rooted in libertarian ideology that elevates individualism and profit at the expense of the well-being of communities, protection of te taiao, and the rights of Indigenous, marginalised and minoritised peoples. Such a framework is fundamentally anti-Te Tiriti, anti-democratic and deeply at odds with collective well-being. Our generation has already faced multiple unprecedented crises, and we know the roots of these crises are because of colonisation and capitalism, the pursuit of profit control over resources and land concentrated into the hands of a few. Through these processes and systems imposed across the world, including in our own homelands, have made them environmental sacrifice zones, sites of exploitation to fuel the demands of capitalism. Land becomes transformed into private property to be bought and sold, exploited and extracted from, one of the key methods of dispossessing Indigenous peoples from their lands. Land and waters that we all rely on to be alive are disrespected and desecrated under these systems. We have learnt from Te Ao Māori and know from some of our ancestors that we as humans must respect and take care of Te Whenua. We are not separate from or above Te Taiao. Anything we do to the environment, we do to ourselves. We have seen this with the devastating floods, extreme weather, wildfires, and pandemics. We are wasting precious time fighting unnecessary and dangerous bills like the Regulatory Standards Bill that belong in the trash, and that has been thrown out multiple times before. We need to focus our energies towards building a future that is beneficial for all of us. If we want to talk about good lawmaking, we need to start with constitutional transformation. If we want to talk about good lawmaking, we need to recognise the first laws of this land, that which is tikanga Māori. Laws that have long existed and practised before the arrival of any coloniser ships and the imposition of the British Westminster system. The RSB is a prime example of the worst kind of lawmaking, breaching the first laws, concentrating colonial power into even fewer hands. Even more concerning is the Regulatory Standards Board, which would have inordinate sweeping powers to retroactively and prospectively assess all legislation through this ideological lens, inviting corporate complaints. In place of these narrow and individualistic values, we believe that the values articulated in Taranaki Iwi offer a far more just and unifying foundation for our country. This work, convened by Matua Mona Jackson and Professor Margaret Mutu, and the visions for constitutional transformation was synthesized from hundreds and hundreds of hui around the country. And these values, like the value of place, of tikanga, of community, belonging, balance, conciliation, and the value of structure, as described, are ones that we want to work forward into a future vision. We have been delivering Mātiki Mai workshops around the country, and again they invite dreams and imagination from individuals to dream and imagine collectively how we would like to live our lives and what kind of society we want to see. And these are often very different groups of people that we meet, but the dreams that they share often sound very similar and are very similar to the values articulated in Mātiki Mai. And I would like to share some of the collective dreams from Asians Supporting Tino Rangatiratanga that we dreamed of together. And it looks like in the future we want to see biodiversity, native plants and animals replenished, reclaiming urban spaces, wildflowers growing instead of mowed lawns. We want to see children laughing, roaming from house to house, with neighbours caring for each other. We want to see a society centred around care with different types of family structures, queer, joyful and free. We see an abundance of food where no one is hungry and the scent of different cuisines are all wafting in the air. We want everybody to be free to speak their languages, to practice their beliefs, to move, to love, to create, to sing, to dance, where everybody is able to be who they are and what they want to be. We want our communities connected, collectively caring for each other. We want to live by the rhythms of Te Taiao, where the decisions centre on protecting and healing the land. We envision a near and inevitable future guided by these values, one that acknowledges he whakapūtanga, honours te tiriti, cares for both people and planet, ensures equitable outcomes and ultimately works to restore the rightful sovereignty of Māori in this land. This is the constitutional direction we are moving towards together, with love, respect, and upon the values that we share. To see this future ahead, this bill needs to be thrown out once and for all. Tēnā koutou katoa.
Thank you. We're very close to time, but I'll take a question from Dr. Megan Woods.
Thank you very much, Kirsty. But one of the things I was just really interested in an excellent submission, but in terms of your fears around the ability to have environmental protections and perhaps putting at risk some of the things that people who migrated to New Zealand migrated here for. I just wondered if you could elaborate on that fear a little bit more. Thank you.
Yes. Thank you so much, Megan, for that question. A lot of migrants migrate obviously for many different reasons, but first is the beauty, I think, of the environment here in Aotearoa, New Zealand. That is the reason why a lot of people migrate. And actually, because of the worsening climate crisis too, we can expect and have already expected a lot of climate refugees, people who are moving because of climate change across the world, and we are already seeing the effects of that happen in this country too. And as a bastion of a place that cares about the environment, it is hugely important that we look after the environment, which means standing up against the mining and fracking of our beaches, of the continual assaults on the forests and on the seas.
Okay, thank you for that. We have met time. Thank you for your submission on behalf of Asians Supporting Tino Rangatiratanga. We're now going to go to Basil Walker. Basil has a personal submission, so it will be limited to 5 minutes. Kia ora, Basil. Can you hear me? I can see you just coming on. Are you there, Basil? Clark, I don't know. Oh, there we go. You've got audio.
Yep. Are you right?
Can hear you. Have you got a video access there, Basil, just to turn your video on?
Oh, mate. Can't be. Must be new. Something's wrong.
No
Never
worries.
mind.
Okay, no problem.
Never-
We've got 5 minutes, so we're in your hands.
Yep. I request the Select Committee to give weight to my submission that supports New Zealand productivity, business growth and confidence, because New Zealand cannot increase business taxation and income without increased growth from business. The examples of my original submission of infrastructure constructed in the South Island have daily proven to be world-class, offering continual service and employment, strong direct and indirect taxation, and an example of progress when unhindered by government regulation, red tape, and obviously including the RMA. My understanding is the regulatory bill will assist in better governance, enabling problems in the legislation to be avoided before being passed into law, therefore avoiding future issues in governance and in the public sector and the various courts. I would just like to add a small bit in there. I've been astounded this morning at the number of submissions that speak of the principles of the Treaty of Waitangi and the partnership between Maori and the Crown. There are none, and the claims are vacuous. I now describe some existing issues, and I submit are an inconvenience to public, arguably contrary to expected and our law. This is where I believe that this legislation of the regulatory bill will assist, because in the outside world or in the rural world far away from Parliament, there is often small issues that have a major impact on our lives. And I'd just like to say, on one, the census has been stated as being stopped or removed recently that a section in the Electoral Act actually requires a 75% majority to repeal or amend the census. This seems to be contrary to what the public have been advised, and the Regulatory Standards Bill would have identified and brought the issue to the attention of the Minister and rectified the issue, because a 75% majority is a major hurdle. Secondly, similarly, the Electoral Act has the power to place a person who has contravened the Electoral Act onto the corrupt persons list and also remove them from voting for 3 years, just for a small mistake or omission when standing for public election, which is an over-the-top punishment, hidden in legislation, arguably double jeopardy and bureaucracy at its worst, and could be fixed by the RSB. The power of competence for local government has seen councils borrow extensively throughout the country, increasing local body debt to a level that individual rates are now huge on debt repayment rather than services, which was the original intent. That the borrowing has been for nice to have rather than targeted at infrastructure is a demonstrable fact. Government is suggesting larger regional group borrowing for water infrastructure, and the RSB will be required to ensure new infrastructural budgets within the general power of competence are not misappropriated against ratepayers in the future. I see now just recently Section 1272E of the Education, Training and Amendment Act 2 could have been improved demonstrably if the RSB had been available. Education has been required to be the secular since 1977 Education Act and not connected with religious or spiritual matters. Clearly, the amendment now before the Select Committee is contrary to the Education Act, arguably contravenes the New Zealand Bill of Rights, and has racial issues that should not be a required priority for all students. And fifthly, it has come to my attention that simple blood test samples ordered by GPs have to be paid for by patients in some southern areas and not in others. Invercargill in Queenstown, no payment. Wanaka in the Southland Township of Winton, payment for blood tests. This is only a sample I have confirmed. However, the RSB would be ideal to identify and bring to the attention of the Minister of Health, because I suspect this discriminatory matter is prevalent throughout rural New Zealand. I trust this emphasises my opinion why the Regulatory Standards Bill will enhance business and productivity in New Zealand. I thank you for the opportunity to speak to the Select Committee from down south in Queenstown. Thank you. Thank you to the committee.
Thanks, Basil. We've actually met time. Sorry, Mark. We're just crunch it back. Thank you for your submission, Basil. We're now going to move to Bianca Burn. Welcome, Bianca. Can you hear me okay?
Yes, I can hear you.
Great. We've just got 5 minutes, so I just encourage you to keep it short if you want any questions from panel members.
Cool beans, thank you. Right, tēnā koutou, and thank you for the opportunity to speak. My name is Bianca Burn, and I'm here to express my concerns about the RSB in its current form. So at first glance, this bill might seem like a positive step, aiming to make sure laws are fair, consistent, and respectful of people's rights. I absolutely support the idea of clearer, more accountable regulation, but I believe this bill could actually do the opposite of what it claims, and I'd like to explain why. Firstly, I'm deeply concerned about the independence of the Regulatory Standards Board. Having board members appointed by the Minister for Regulation risks turning this into a politically influenced body rather than a truly independent one. If the board is responsible for judging whether laws align with key principles, we need to know it's free from political agendas, no matter who's in power. Secondly, I want to highlight the risk that these regulatory principles, though well-meaning, could be used to challenge or undermine laws that are genuinely in the public good. For example, laws that help protect renters, limit environmental harm, or promote public health could be attacked under this bill if they're seen as interfering with property rights or personal freedoms. We need to ask whose freedoms are being prioritised and at what cost to others. Thirdly, I am disappointed that Te Tiriti o Waitangi is not included as one of the key principles in this bill. This is a serious oversight. Any legislation that aims to improve how we regulate and govern must include our foundational document and the rights and responsibilities it upholds. Without this, the bill risks repeating the same patterns of exclusion that have harmed Māori communities for generations. I also worry about the extra powers being given to the Ministry for Regulation to demand information from agencies, including community organisations. Oversight is important, but it must be balanced with trust, transparency, and respect for privacy, especially when dealing with groups who support vulnerable people. To sum up, I believe this bill gives too much power to central government and too little protection for the public good. If we want better laws, we need inclusive, transparent, and truly independent processes, not systems that could be used to block progress or silence community voices. I strongly urge the committee to reconsider parts of this bill. Please protect the independence of the oversight body. Include Te Tiriti or Waitangi as a core principle, and ensure this bill cannot be used to weaken the kinds of laws that protect our health, housing, and environment. Thank you for your time. Ngā mihi nui.
Thank you, Bianca. There doesn't appear to be any questions, but I would like to thank you for taking the time. I really appreciate that. Committee, we're going to break for a short break. We might come back at 10:44. I'll try and claw back some time, but we'll just have a 7-minute tea break. Thank you. Hi, Bronwyn. You're worried about your sound? Is all good?
Can you hear me?
Yeah, can hear you. That's great.
Fantastic. Thank you.
Get underway shortly. Okay, we have quorum, so if it's all right with the clerk, we'll get underway. Welcome, Bronwyn. You have 5 minutes, but of course, if you finish early, we might have some time for some Q&A.
Thank you very much, and it's a privilege to be able to speak. I will speak very briefly and answer questions. So I'm a Professor of Political Science and I specialise on environment, climate and issues for democracy. I was just thinking that in the last 30 years I've taught thousands of students of all political persuasions about New Zealand politics. There are 3 points that I want to make. I'm worried that this bill creates deep uncertainty, particularly its retrospective nature, and because it narrows the principles of regulation so tightly. Other colleagues, including Dr. Jones, who will follow, will speak much more eloquently about the treaty issues and the human rights issues which we could consider. But the Commissioner for the Environment has highlighted the uncertainty and need that urgently we need to pay attention to redefining how we are treating property rights in the context of the environment. But I just want to talk about something completely different. The example of my mum and 50,000 New Zealanders who are in retirement villages around the country. This retrospective legislation opens up deep uncertainty for all of those who under the Villages Act have finally been able to get some provisions around codes of conduct. That's one example. Secondly, the bill is very inefficient. It effectively creates a super ministry over and above all other legislation, and it's incoherent with our fast track legislation. I submitted on that, and unlike other colleagues, while I have deep reservations, I don't entirely disagree with the fast track legislation. In my role in the IPCC, chairing the infrastructure panel, it is important that governments can make fast and wide decisions. In a state of an emergency, like we experienced in Christchurch. I'm not sure if our Prime Minister was in Christchurch at the time, but certainly he and many others would have had loved ones who remember how we had to make really difficult and quick decisions. I remember this now Speaker of the House talking about old dunga buildings. Now, how will we be able to make nimble, fast decisions under this legislation? And thirdly, I want to talk about the sweeping powers of the Regulatory Standards Board, which is really an Americanization of our politics. I can't find any controls over who's appointed. Now, I hardly think it's likely that the Minister of Regulation would appoint Elon Musk to that board, but I can't see anything that would stop him. Just this morning, Minister Jones was talking about the problems he argues we're outsourcing legislation and litigation. But leaving this door open to anybody to be appointed to do basically anything, including implement their own investigations into the democratically elected parliament and its processes is extraordinary. It paves the way for corruption and it paves the way for the kind of fiascos we've seen in the US. It isn't appropriate. It isn't the New Zealand way. Tēnā koutou.
Thank you. Question from Francisco.
Thank you, Chair, and thank you for your submission, Professor Hayward. I'm really interested in point 6, and I was wondering if you could elaborate further on that, because it's not something that I've seen other submissions stress that much. Can you elaborate how do you think the bill will usurp the role of Cabinet?
It has a coordination function, and it has a responsibility to make sure that legislation is coherent. But this superpower of a regulatory board suddenly sweeps in before that. It's not even clear who that board is responsible clearly to, and when preparing responsibilities, how that how those people, the chief executives that are preparing those commentaries, who they are responsible to. Are they responsible to their own minister? Are they responsible to the Minister of Regulation? It's extraordinary. I mean, it leaves the government extremely weak in this situation. And really, two very small parties, but particularly one in this case, have really gazumpted government, the party of the largest vote. It is an extraordinary situation.
And very quickly, Megan Woods.
Thank you, Bronwyn. Excellent point around emergency regulations and dealing post-disaster. Your experience, I just wonder if you could elaborate on that in a couple of sentences, how you think that might interact with, say, any emergency ledge.
It's very serious. From our point of view from the IPCC, we note that children that are born in 2020 will experience 4 times the extreme disasters that anyone that was 55 or older in 2020 will ever experience in our lifetimes once we go over 1.5 degrees of warming. So basically that's already bedded in. So 4 times the extreme events that we've seen now is unimaginable for people my age and older. We need legislation that's looking to the future, that can be fast and nimble. We don't need international companies and organisations popping in to slow down the legislation that our locally elected, democratically elected decision makers need to make for the good of the country.
Thank you for that. Thank you for your submission. Really appreciate that, Bronwyn. We're now going to move to Carwyn Jones. Carwyn, you're online. Again, the personal submission, you have 5 minutes. Encourage you just to finish a little early if you'd like to take some questions. In your hand.
Tēnā koutou. I'm opposed to this bill because it will limit the ability of government to implement laws and policies that are in the public good. Equity, human rights, te tiriti o waitangi, environmental protections, in fact, anything that is in the best interests of New Zealanders would be subordinated to the profits of corporations under this bill. Let's be honest about what the intent of this bill is. The intent is to reshape as much of New Zealand law and policy as possible to conform with the ACT Party's radical libertarian agenda, so that foreign companies and the wealthiest individuals can profit even more at the expense of the vast majority of New Zealanders. This bill has nothing to do with improving the quality of regulation. If the ACT Party were genuine about improving the quality of regulation, this bill would not have been developed in such a shoddy way. There's no policy rationale or problem definition, and when the Minister has been confronted with reasoned arguments against the bill, he's not been able to provide a counter-argument. Instead, he has responded with childish name-calling and suggested the hundreds of thousands of people who have taken time to make submissions are bots. This level of contempt for New Zealanders participating in the legislative process is a long, long way from what most of us would consider to be part of good lawmaking. All government agencies who have provided advice on this, even the Ministry of Regulation, have advised against this bill. No proper consultation has taken place. But clearly, when you're driven by a radical ideology, there's no room to listen to the views of people affected, research or evidence, advice from officials, input from anybody with relevant expertise, or even to consider the well-being of New Zealanders. But legislating on vibes alone like this is lazy, careless, and dangerous, and it's simply not good enough. New Zealanders expect and deserve so much better. If National and New Zealand First allow this bill to pass in its current form, they will ensure that the legacy of this government will be that ACT Party policy is embedded across our entire legal and policy landscape. They will have sold out not only their own supporters, but all New Zealanders by enabling ACT's radical libertarian ideology to shape all our law. But if ACT's coalition partners do want to stand up for New Zealanders against the interests of multinational corporations, there are 5 simple amendments that could be made to this bill. 1, replace the criteria in the bill with actual principles of good lawmaking. You could use the current legislation guidelines as the basis for this. 2, remove the Regulatory Standards Board. 3, remove the powers that the bill would grant to the Ministry of Regulation and its minister. 4, ensure the bill only applies to new regulations and does not require existing regulations to be reviewed. And 5, extend the list of exceptions to include any measures aimed at implementing human rights, te tiriti o waitangi, equity, environmental protections, or policies for the public good. The bill would still be unnecessary and deeply flawed, and I maintain the best option is to reject it entirely, but at least with those 5 amendments, New Zealanders would not be subject to a radical libertarian straitjacket. Tēnā koutou.
Thank you for your submission, Carwyn. We've got a question from Megan Woods.
Thanks so much, Carwyn. Agree, the best option is to scrap the bill in its entirety, but really interested in the alternatives that you've put up in terms of suggestions for amendments. One of the ones I just wondered if you go on a bit more about making this only forward-looking and not retrospective, so only applying to new regs not existing.
Yes, well, I think that makes sense in terms of the way in which, in terms of limiting the kind of constitutional overreach, which I see as deeply problematic in this bill at the moment. Part of it is that it intends to reshape the entire legal landscape, including the existing laws. And I think that does kind of create a retrospective aspect to it that is bad lawmaking. And so by limiting it simply to thinking about how to put in place some measures to actually increase the quality of legislation going forward would resolve some of that.
Thank you, and thank you for your submission, Carwyn. We are now going to move to Chris Till. Chris is online. Again, a personal submission, so just 5 minutes. Where are you, Chris? There you are. You there, Chris? Just need to take your audio off and video on. Perfect. Thank you and welcome. You've got 5 minutes.
Yeah, first of all, a bit of a protest. Who and why was the decision made to give 5 minutes to individuals and 10 minutes to organisations?
It's a long-standing parliamentary convention which you're actually eating into now, so I'd encourage you to make the most of it.
No, I won't be dismissed like that. I'd just like to put down a protest that it's actually not democratic to do that. I'll move on to my statement, which I'll read out, and I'll try and do it quickly enough for you to ask any questions, which hopefully won't be biased in any way. The government should scrap Te Mana o Te Wai and national bottom lines, allowing regional councils to set their own standards. Vague concept of Te Mana o Te Wai replaces scientific benchmarks with a subjective idea of the manner of the water that leads to co-governance and unequal treatment based on who someone's ancestors were. Now that's, in my book, racist, tribal and anti-democratic. Iwi have an unacceptable right of veto over how water is used. Consenting is now subject to consideration of Maori, or the life force of water. This has led to water users making large one-off and ongoing payments for cultural monitoring services, which do nothing for the environment but add costs to consumer and business power bills. Farmers just want to grow food and look after their land. Incorporating spiritual concepts isn't necessary for them to do that. That's what happens when we regulate water quality based on superstition and not science. Te Mana o Te Wai has led to confusion, time and money being wasted, and a whole cottage industry of cultural consultants costing an arm and a leg. Let local communities decide what standards work best for them. Standards set nationally aren't appropriate for all catchments. We've got diverse geography and conditions, means farming practices vary across regions, and I've been in most of them, as farmers adapt best practice to the local conditions. Blanket regulations set by big government bureaucrats in Wellington are unsuitable. We need to remove subjective, racist, tribal and anti-democratic requirements to ensure our freshwater management is scientifically sound and adapted to the needs of local communities. In conclusion, I wish to express my strong support for the Regulatory Standards Bill and for option 3 regarding the rebalancing of Te Mana o Te Wai in the National Policy Statement on Freshwater Management, which calls for the complete removal of Te Mana o Te Wai from the policy. I strongly believe removing Te Mana o te Wai from the national policy statement will pave the way for clearer and more effective management of our freshwater resources, one that is based on evidence, science, and a shared understanding of the issues we face, and not on racism, tribalism, and anti-democracy. Thank you for taking the time to consider my feedback. I act in the best interest of all New Zealanders, and I'd like to repeat my complaint that I don't care what the standards there are at Parliament you set, because that's the way we've always done it. It's absolutely wrong that people like me get half the time of some of the previous people who've been talking and have presented long presentations on the basis that they're from organisations. I really do strongly object to that, so I'd like that noted. Right, you can ask me any questions now.
We have a question from Mark Cameron.
Thank you for ignoring me, Chair, and for not addressing it, and for trying to put me down with saying that's the way we should always do it.
That's not what I said.
Yeah, but it was implied, and there was a sarcastic tone. I've submitted these things before, and there's always an element of us and them, and I'm definitely in the category of them. Although actually, I speak for a lot of people in New Zealand who actually never articulate this because they're afraid of being called racist or anti this or anti that. Questions?
Yeah, with respect, this isn't the time or the place.
No, that's another put down.
Okay, I'm actually going to end the session, so you now lose your question, and we're going to move on to the next submission. We're now going to hear from Christine Cheyne, who is a personal submission also, and she has 5 minutes. I'll just wait for her to take. Welcome, Christine.
Tēnā koutou katoa. You're hearing me okay?
Yep, you're good to go.
Good. Right, thank you. Oh, thank you for the opportunity to make a submission. I realise it is quite a privilege to be here when so many would have not had the opportunity. I have made probably very similar comments to a number of the other submitters this morning, and there's been certainly some eminent people speaking to you. Just to rehearse the key points of my submission, the bill is unnecessary, poorly conceived, unsupported by evidence, and generally not fit for purpose. That's pretty damning. Why am I making this submission? I have, I believe, some relevant expertise. Hasten to claim any expertise, especially of an academic kind, because of the criticisms that are made of some other academics. But I think it's important to look to where expertise lies and to draw on evidence. And I have taught in social policy and politics. A number of the themes in this bill relate very closely to the kind of material that students learn in those subjects around values, social theory, visions of society. And the principles in the bill are informed by a very narrow set of values and a very impoverished set of values, actually. And I think it's really important to listen to the submitters who have expertise in practices around political philosophy and political science. Just as if I have a problem with my plumbing, I go to an expert. I'm not a plumber. So I implore you to listen to the experts in political science who have had some very important things to say about the workability of the legislation and about the inclusiveness of the principles. And I concur with some of the comments just made previously by Dr. Carwyn Jones about the modifications that could be made. One of the things that particularly concerned me was the responsibilities and the power given to the board and to the minister, and they are fundamentally, I think, altering our constitutional arrangements, and they need far greater consideration than what has been possible with a submissions process and passing legislation under urgency. I'll leave it at that. Hopefully there might be some time for clarification or questions.
Thank you, Christine. Yes, we have a question from Mark Cameron.
Sorry, Christine, great submission. And thank you for your very clear and concise language. I do have one question though, however, and you did say drawing on evidence, and I'm using your words perhaps against you. How do you square, Christine, that people that are users of secondary legislation, i.e. regulation, quite often are the best to draw on that evidence, and they've come to some parliamentarians in saying that the regulation is not fit for purpose. Now, in that moment, how do we square what good regulation looks like in the absence of something that is a check and balance of it? So what's your thoughts on that?
Well, I guess the classic academic response, but a good policy, robust policy response is to do research, to get evidence, to get data, and to weigh it up. And that obviously will take some time, and that's sometimes what is needed to get policy that's fit for purpose. So certainly investigation, data, evidence to support claims made about the workability of regulation or the unworkability of it.
Christine, just very quickly, would you also employ those extra services that would look at cost benefit analysis, and upon doing so, remove secondary regulation or duplication in that instance?
I'm not sure about removing it, but I certainly think that's one of the tools that you can use, but it's not the only tool, cost benefit analysis.
Thank you.
Thank you. Thank you, Mark. And thank you, Christine, for your submission. Appreciate that. We're now going to move to Common Grace Aotearoa. I believe we've got Alex Johnson.
Yes, kia ora. Can you hear me okay?
Kia ora, yes, welcome. So as part of an organisation, you have 10 minutes. I think you've done this a few times before, but if you save some time for Q&A at the end, that's always helpful.
Thank you. He honore he kororia ki te atua, he maunga rongo ki te whenua, he whakaro pai ki ngā tangata katoa. Tēnā koutou I rau Rangatiratanga, ko Alex Johnson tōku ingoa, he tangata Tiratia hau. My name's Alex, I'm one of the co-directors of Common Grace Aotearoa, and it's my privilege to be presenting our submission today. Common Grace is a movement of 3,500 followers of Jesus from all denominations across Aotearoa that speak up together for climate, economic and te tiriti justice. We work towards a vision that's to see the flourishing of all people and the earth by transforming unjust structures in society. We're here presenting on this bill because we believe that Jesus' way of using power is in sacrificial self-service to bring about the flourishing of all people and the rest of creation. And we're deeply concerned at how the Regulatory Standards Bill would rewrite laws and restrict future governments to make rules and allocate resources in line with this vision. So our key concerns that we outlined in our written submission are that this bill would sideline Te Tiriti o Waitangi and its principles. This bill will restrict our collective ability to protect the environment or God's creation. And this bill will impact on our shared well-being and efforts to protect the common good. So I want to speak to a couple of those points and then highlight some of our key issues with the principles that are contained in the Act, in the bill. So firstly, in the area of Te Tiriti o Waitangi, governments and our lawmaking and regulation making processes should seek to honour Te Tiriti, not sideline it. So we are the organisation that coordinated an open letter from church leaders stating that they opposed the Treaty Principles Bill as it was going through. At the time, we had 440 church leaders sign from the most senior leaders of Catholic, Anglican, Methodist, Salvation Army, and Pentecostal denominations, and that number of signatories is well over 600 church leaders now. That letter stated that we affirm that Te Tiriti o Waitangi protects the Tino Rangatiratanga of Hapu and Iwi, and that the Treaty Principles Bill was inconsistent with that by not recognising the collective rights of Iwi Māori or guarantee their relationship with the Crown. And it would undermine what Te Tiriti o Waitangi guarantees and what decades of law, jurisprudence and policy have sought to recognise. Now, much of the content of that letter also applies to the Regulatory Standards Bill in the way that it sidelines Te Tiriti and its principles from good lawmaking. This current bill is a highly selective and unwarranted selection of principles of what supposedly good lawmaking is. Missing from that list of principles are Te Tiriti o Waitangi and its principles itself, as well as widely recognised constitutional principles like the public harm principle, ideas of distributive justice, protecting the right to a healthy environment, the interests of future generations, the precautionary principle, the requirement for governments to comply with their international obligations and international law. And so we think this is a very restrictive set of principles that are highlighted, and what's chosen to be included and what's left out. But also the wording of those that have been chosen, we believe, is highly problematic in their lack of definition and their broad scope. So to speak to the liberties principle, that is focused on the liberty of the individual and the idea of the private harm principle, but it completely ignores the public harm principle. The idea that if we should be able to restrict individuals' liberty to protect the public good, that if our local waterway or a wahi tapu needs protecting from pollution, or if a government wants to lift health outcomes by prohibiting a dangerous product, we don't want the idea of individual liberty to stop governments from doing that and achieving those public good outcomes and preventing public harm. Secondly, the regulatory takings principle. This has many issues, but I want to quote from Professor Jonathan Boston that if, in effect, this principle would replace the polluter pays principle with the idea of non-polluters pay, and that it would actually force payouts from the collective and those that aren't causing harm to the environment or to the common good to compensate those companies and corporations that are causing harm to the common good. One of the examples that Common Grace works on in this regard is looking on how we end free carbon credits in our emissions trading scheme. And if we take that regulatory takings principle to its full effect, that would suggest that we need to compensate companies if we decide to regulate them by putting a carbon price on them. And that's simply not consistent with how we achieve the common good and protect the environment and achieve our international obligations. Thirdly, the taxes, fees and levies principle. We believe that it's irresponsible and impractical to try and legislate that taxes and levies should have this direct correlation to the cost of the good or service, or that they should benefit the people paying such a levy, because many levies currently imposed by central government and local government are not designed primarily or even partly to benefit those on whom they are imposed, but rather to benefit the collective as a whole. We cross-subsidise health, we cross-subsidise public transport, education. These things don't have necessarily a direct correlation to those that are paying the fees, but we set them in place for the common good. People deserve to live in homes that don't leak, enjoy nature without pollution, return home safe each day from work, and we use regulations to ensure that this happens, even if it impedes the way that some want to do things or their property rights. We believe keeping each other safe is more important, and that property cannot take importance over people. And regulations, taxes and levies have a critical role in serving and protecting the public good, not just those whose so-called liberty they might restrict. What this boils down to for us is that we are part of a collective. You might call that a society, a community, a nation. And in Christian terms, the Apostle Paul in Corinthians uses the metaphor of the body and its many parts and how we rely on each other to thrive. So to quote from Corinthians, if the whole body were an eye, where would this be the sense of hearing? If the whole body were an ear, where would be the sense of smell? But as it is, God arranged the members in the one body, each of them as he chose. If all were a single member, where would the body be? As it is, there are many parts, yet one body. The eye cannot say to the hand, I have no need of you, nor again the head to the feet, I have no need of you. On the contrary, God has so composed the body, giving greater honour to the part that lacked it, that there may be no division in the body, but that the members may have the same care for one another. If one member suffers, all suffer together. If one member is honoured, all rejoice together. So, members of the committee, the bill before you does not serve the body to which we are all a part. It does not serve the common good. And so Common Grace Aotearoa recommends that the committee recommend that this bill be dropped in its entirety. Thank you for the time to make a submission, and I welcome your questions.
Thank you, Alex. I see Megan's dropped off, so Mark Cameron. You there, Mark?
Sorry, I'm having technical issues. So, thank you, Alex, very much, and thank you, Mr. Chair, for allowing me to have a question, maybe two. Alex, do you agree that laws in New Zealand are quite expensive to make, as it were, or have passed in Parliament?
Well, all functions of government have a cost, and that's part of how we organise society. What I would say is that if this bill were to pass, that it would actually add costs to the cost of lawmaking, because we already have several processes like regulatory impact statements. We have the Crown Drafting Office for drafting up legislation, but if you were to add the Regulatory Standards Board in place and the requirement of public service chairs to, produce reports, you're actually adding increased processes to the functions of lawmaking, and that's going to increase costs.
Thank you for that. I'm just cognizant of the fact that suffice it to say that the premise of the bill is to try and reduce waste in Parliament. But I have a follow-on question. If in fact we do agree that laws do cost a lot to pass in Parliament, how is it so, sir, that we agree that we have about $146 billion operating cost in government, which has about a $6,000 interest cost per every living human in New Zealand? Would you then square that if we can reduce the burden on duplication in our parliamentary process, in our lawmaking process, that would be a good thing for all New Zealanders? Would you agree or disagree?
I think that this bill creates a level of duplication in the lawmaking process and duplicating system, checks and balances that are already in place. And I don't think it is, for example, the bill's not necessarily making a choice about how you reduce costs. It's making a choice to elevate certain principles over others. And so it's not, I think the question doesn't necessarily speak to what the heart of the bill is about, which is about elevating certain principles over others. There is a good reason why we might reach different opinions on what principles should be in lawmaking, but to put in primary legislation certain principles over others, and ignoring key constitutional ones, that's not necessarily a question of how you reduce costs. That's a question of what ideas should form or should be able to should form the types of laws that we make or the types of regulations.
Okay, we have gone over time, gentlemen, so we'll end there. Thank you, Alex, for your submission. Appreciate that. We're now going to move to Communities Against Alcohol Harm. Is it Nathan we've got presenting?
Yes, that's correct.
Welcome. You've got 10 minutes, and encourage you to just finish a little bit early to allow time for questions. In your hands.
Thank you, Mr. Chair. Kia ora tātou. My name is Nathan Cowie. I'm a Community Affairs Advisor, and I'm speaking to the committee on behalf of Communities Against Alcohol Harm. Communities Against Alcohol Harm does not support this bill, and we recommend that the bill is abandoned in its entirety. If this bill passes, we are concerned that private economic and property interests will be even more prioritised over community interests than they are already. So Communities Against Alcohol Harm, we support communities who are navigating alcohol licensing applications in order to reduce alcohol-related harm across Aotearoa. We work with individuals, whānau, hapu, iwi, community organisations, public health, alcohol licensing and enforcement professionals who actively participate in the local alcohol licensing process. We work to make safer environments that reduce the accessibility, affordability and acceptability of alcohol in areas where alcohol harm is high. Our purposes are to A, minimise alcohol-related harm through advocacy, community action, fostering networks, education and training, and B, to respect the dual heritage of the partners of Te Tiriti o Waitangi. We recognise that the expectations of regulatory decision-making processes are essential for protecting the health and well-being of Aotearoa, and we do appreciate the opportunity to comment on the Regulatory Standards Bill. As our written submission says, we hear strong evidence of alcohol harm from technical experts like researchers, academics and organisations in the field. The knowledge base on alcohol harm in Aotearoa is strong and growing. And what we consistently see and hear is that alcohol is the most harmful drug currently available in Aotearoa. Alcohol harm and its costs are increasing in many areas. And alcohol harm is not equally distributed. Alcohol is a health equity issue. Alcohol harm is a Māori health equity issue and a Te Tiriti o Waitangi issue. Alcohol harm is broad, affecting many areas of health from acute, for example, poisoning, injury, suicide, through to chronic illnesses such as cancer, dementia, liver disease, mental health, addiction, and impacts right across the broader determinants of health and well-being, relationships, social cohesion, amenity, good order, crime, violence, etc. Now, we also hear strong evidence of harm from those with lived experience. And in the course of our business, we hear from these people who have lived experience of alcohol within their communities and of the harms that they and their communities suffer. Lived experience expertise is recognised as key to improving health, mental health and social services. I myself am a survivor of alcohol harm. I've been harmed by my own drinking and the drinking of others. I've harmed others from my own drinking and seen people harm themselves and others from their drinking. I've lived with the effects of traumatic alcohol harm for over 30 years, and it's impacted every aspect of my life. For me and hundreds of thousands of others, alcohol harm is a normal part of everyday life. People with lived experience are concerned about alcohol harm that impacts beyond the drinker. We are concerned about health, mental health, relationships, social cohesion, well-being, whānau and community economic situations, amenity and good order, the likelihood of crime, and about violence and family violence. Our concerns are also backed up by the 2024 research, which emphasises the costs of alcohol harm to Aotearoa at $9.1 billion per year, and highlights harms to people beyond the person drinking, showing that at least 1/3 of investigations into family violence involve alcohol. The study also showed that children with parents who have an alcohol-attributed hospitalisation or mental health and addiction service have a 65% increased risk of maltreatment. My peers in recovery from alcohol and drug addiction have high needs. The harm we experience reverberates around families and communities. We need support not only to overcome our addictions and recover from harm, but to rebuild our lives, stop offending, stay out of jail, find safe housing, reconnect with children, find employment, education and training, and to become healthy, functioning members of society again. At Communities Against Alcohol Harm, we try to prevent these kinds of alcohol harm, primarily through reducing the availability and accessibility of alcohol. In doing so, we often come up against economic and property interests. If this bill passes, we are concerned that these private economic and property interests will be even more prioritised over community interests than they are already. And this is despite the huge 9.1 billion with a B dollar economic burden of alcohol harm on our communities. We do not support this bill, and we recommend that it be chucked out. Thank you.
Thank you, Nathan, for your submission. Appreciate that. Very fulsome. We don't appear to have any questions, so we'll leave it there. But thank you once again.
Thank you very much, Ryan.
Okay, committee, we'll now move to Hapai Te Hauora, Tapui Limited. Oh no, sorry, I missed Community Law Centre. Lawrence, I've skipped ahead. I think Lawrence is ready to go.
I think I was muted.
Oh, okay. Yep, we can hear you. Can't see you.
Yeah, sorry. Yes, kia ora tātou. My name's Lawrence Kimberley. I'm from Canterbury. I'm representing the Community Law Centres Aotearoa, which is a...
Lawrence, have you got a video at all?
Oh, yes.
Not
is it off?
but...
Yeah. Can you see me now?
Yeah, brilliant. Thank you.
Apologies for the technical issues. I'm representing Community Law Centres Aotearoa, and I'm also a manager of the centre itself, but we've got a network of 24 law centres across the country, and we provide free legal services for those who would otherwise not be able to access justice. So we have quite an important role, mostly dealing with or working with the vulnerable in our communities. We're opposed to this piece of legislation. We would like to see it dropped, frankly. One of the main issues for us is the principles which this is going to be relying on, which is around economic and private equity grounds for proposing legislation and getting that through Parliament. We think that there are other strong arguments for the principle of looking after the public good. We obviously represent vulnerable people. We want to make sure that they have their well-being protected through good legislation and good regulation as well. Many of them will not have personal or private property, so we think that there's a risk that there will be more systemic harm for these people. So we don't want this bill to diminish their rights and to make their human interests subservient to the private property rights. I'm also concerned that this will add to the cost of legislative process as well. I think this will be almost like a ticking time bomb that will sit within Parliament. What will happen is that if the legislation's passed, then there'll be a process of people being able to lay complaints with the Regulatory Standards Board, or people will be producing lots of reports. That's going to sit over ministers and parliamentarians, and there'll be political consequences for those that don't listen, and it's actually going to slow down and inhibit the whole process of lawmaking, which I think would be a bad result. At this point, I was going to have two other people taking over from me.
Kia ora.
Yeah, thank you.
Kia ora. My name is Rupert O'Brien. I am one of the law reform coordinators at Community Law Centre Aotearoa. I'm meant to be being joined by my colleague Karen, but I think she might not have been let in. But in any case, I'll just carry forward. From what we see, this bill is intended to promote the interests of large property owners and businesses. For community law centres, the whānau that we see, as Lawrence said, not property owners or business owners, and those who might find themselves bound by regulation. The people we talk to are those who rely on regulation to protect their well-being, protect their ability to live decent lives and to participate in society. The approach that we see taken by this bill diminishes their interests and sets to make human interests subservient to private property rights. Indeed, from the perspective of speaking to and assisting the poorest and most vulnerable, our experience with regulation in New Zealand is actually that it is quite limited and often not even sufficient. Where it does exist, we find that it is often light touch. For example, I think of the current credit contracts and Consumer Finance Act affordability regulations that really do not properly protect vulnerable borrowers or restrict high interest lending. But even where there are regulations that protect New Zealanders, we find in our experience that they're often not actually well enforced, and they instead require individuals to take stressful and potentially risky legal action to protect their rights. I think of the regulations like the Healthy Homes legislation and even the Wages Protection Act, which are very firm on paper and protect the rights of Kiwis to live in decent housing and not have their wages stolen. But enforcement of these is pretty limited. And we see breaches of these rules every single day at community law centres across the entire country. In effect, the social regulatory system such that it exists that we see already does not adequately protect the interests of people in New Zealand or the environment. So we express a deep concern that this bill intends to and will have the effect of reducing the already limited and insufficient regulatory environment that we presently have, and it will have a chilling effect on future government intervention that is necessary to prevent harm to whānau and to our environment. I'd also take a minute to direct the committee's attention to the takings clause. While the bill has chosen to take some sections of the Legislative Design Advisory Committee guidelines and leave others behind, it has introduced an altered version of the LDAC property takings clause. The LDAC states that the law may allow restrictions on the use of property for which compensation is not always required, whereas the RSB instead introduces an undefined impair of property clause. This leaves impairment of future lost earnings as something a well-resourced and litigious group, such as, for example, tobacco industry, could pursue in the future. Or, for example, something that was recently done is restriction of vape access. You could see that as being a future lost earning that could be sued for. This is a huge constitutional change to our current takings rule, and has not been really properly assessed. Not sure if Karen is here. Excellent. I'll pass to Karen now.
Tēnā tātou katoa. Thank you for having us here today. The last point I really just want to make from our submission to emphasise is our concern about the concentration of power in the hands of one minister in particular, that minister can set out guidelines on how those principles should be interpreted and applied, determining which types of regulations are exempt from the requirements, and directing the review of existing regulation. We think that more effective measures would be to strengthen the current processes, to do them well, to use the Regulations Review Committee, and doing current lawmaking processes such as ensuring that select committee processes are happening. We just referred to the recent skipping of those processes in the pay equity legislation and also the social assistance legislation, accommodation supplement and income related rent bill. Those are incredibly important processes for civil society and communities to be able to have a say into what legislation looks like. The other thing we would add about that is just that the amount of regulatory impact statements that are currently coming through where there hasn't been consultation with the people that should have been consulted, there hasn't been enough time to fully consider other alternatives, and we just think that those processes of evidence-based lawmaking, of taking the time to really consider the policy options, are really important, and that would be a better process than putting these principles in place in this regime. There's also a question around confusion around what happens to the LDAC guidelines, what happens to I think it's the Cabinet Impact Analysis process, what happens to Part 4 of the Legislation Act now. We already have these things in place and we should be doing them well. Kia ora tātou, thank you.
Thank you, Karen, Rupert and Lawrence. We have a question from Francisco Hernandez.
Thank you, Chair, and thank you to the Community Law Centre for the submission. I just have a quick question. I think you've made the point very loud and clear around the sort of principles-based objections to the to this regulatory standards bill, but is there any sort of practical way that the regulatory standards bill could, for example, lead to an increase of workload or inhibit how the CLCA currently functions that you haven't mentioned in your submission?
I don't think it would have a direct impact on our practice as such, other than those regulations, if there were to be regulatory changes to the Lawyers and Conveyancers Act or the rules associated with that, which could potentially occur. It would be more the direct experience of our clients. You know, I would be really worried about, for example, the legislation that we rely on, such as the social welfare regulations, the healthy homes regulations, those CCCFA affordability regulations that we do our very best to protect our clients with, such as we can, and without which, you know, if they were to be reduced, revoked, removed, something by this method, would put our people in a much worse position. That would be the effect that we would be worried about.
Good.
Okay, thank you. Thank you for your time and the work that you all do. Appreciate your submission today.
Kia ora.
Kia ora.
We're now going to move to Hapai Te Hauora Tapui Limited. There'll be another organisational presentation of 10 minutes. I can see the Hapai boardroom. Kia ora.
Kia ora. Kia ora tātou. Ko Jackie Hardy mai tōku ingoa, he iri tēnei no ngāpui, ko au te tumu whakarai Hapai Te Hauora. Kia ora Jackie, thank you for having us today, and I'm the CEO at Hapai.
Kia ora koutou, ko Jason Alexander taku ingoa, hiri ahau no te tai tokarau. I'm the Chief Operating Officer here as well.
Kia ora, in your hands.
Thank you. Before I begin, I want to acknowledge someone who embodied what it means to stand for her people, and the late takutai Tash Kemp, the MP for Taranaki Iwi. Tash was a force on Manurewa, and she stood firm for whānau and her mokopuna in the marae communities and in Parliament, and she understood that leadership means protecting your community from harm, calling out injustice and making the system work for those too often excluded. And it's in that spirit of protection, resistance and unapologetic community leadership that we present our submission today. Hapai Te Hauora is a kaupapa for Māori public health organisation with nearly 30 years of experience in Māori public health, jointly owned by Iwi and Urban Māori Authority, which gives us a foundation and live realities of our people on the ground and not just theory. We lead in health promotion, research, community engagement, civil education initiatives to reduce harm from gambling, alcohol, tobacco, vaping, drug use, mental health, and we also promote preventative care and awareness around immunisations, chronic illness, FASD, and sudden unexpected death in infancy or SUDI. We are here today to express our strong opposition to the Regulatory Standards Bill and take our submission as read. Our focus today is on its real-world risks to Māori public health, equity, te tai ao, and te tiriti o Waitangi. This is not just our view, it is the view of thousands. Between November 2024 and early this year, public submissions on the draft Regulatory Standard Bill were called for. Of the 23,000 submissions received, nearly 90% opposed it. For us, that's not a marginal view, that's a clear rejection from our communities across Aotearoa. When the full bill was released, we saw the same response. Hapai Te Hauora supported over 4,000 people to make submissions. Whānau, rangatahi, māma, kaumātua, all standing up and having their voice heard. Let's be clear, our people are not bots. They did not copy and paste standard comments. They were real people with real concerns taking part in a democratic process that means to reflect their voices. We are proud to have helped amplify those voices and make this process easier to navigate. It's always a privilege to be entrusted with our people's kōrero and to show that their whakaaro matters.
It would be remiss not to highlight the flawed process that we're now faced with, and I know others have already brought this up, but I just want to touch on our experience. So only 30 hours were allocated for oral submissions, which seems like an incredibly tight window given the scale of public's concern and the far-reaching implications of this bill. Compounding this, a lot of people face technical issues with the online portal again, creating further barriers to participation. We had many whānau that were messaging us saying that they couldn't use that portal. So we made two formal attempts to seek clarity from the committee, asking how submissions would be processed and published. Once again, that was based on the process that we ran with the TPB earlier. In our first message, we asked whether submissions would be treated individually or grouped, what formats would be accepted, and how decisions would be made about what gets published. And these were all questions that came through from communities directly to us, so we were just seeking clarity for them. The first response we received was quite vague, so we followed up for further clarification, and that was met with an automated reply in crickets. So there was no answers, no engagement, no transparency, and I just want to highlight again that this erodes trust in the process, and it fails to meet the very standards of good lawmaking which this bill claims to uphold. As a Māori public health organisation, we are deeply concerned about the harm this bill would cause for whānau Māori and the dire consequences for Māori public health. As everyone on this call already knows, Māori already live 7 years less than non-Māori, experience higher rates of diabetes, suicide, smoking and preventable illness, and we are deliberately targeted by alcohol, tobacco, gambling and fast food industries every day. This is all the result of policy decisions. And this bill continues that damaging legacy and has real potential to open doors for industries to be even less regulated at the expense of public health. This is a trade-off that we see that this bill it will have. So it gives more weight to industry rights and collective well-being, and it weakens the space for equity-focused Māori-led solutions. Worse still, it gives legislative dominance to the very industries that profit from harming our people. Once again, tobacco, alcohol, gambling, and fast food. These are the same industries that oversaturate their outlets in our communities. They target our tamariki with predatory marketing, and they exploit regulatory gaps to entrench their presence. Just down the road from here at Wairakei, there's a 24/7 McDonald's being built directly across from Iwi Gardens, a kura, and a community centre, despite overwhelming community opposition. And this is a stark example of what happens when industry interests are privileged at the expense of community well-being. The RSB, as proposed, would likely see examples like this exasperated, giving more access and protections to fast food industries who exploit our communities for profit. Alcohol is cheap and available everywhere. Tobacco companies are now pushing vapes to keep our people addicted. Gambling operators are already using Māori influences to illegally reach our communities and tamariki. This isn't some distant risk, it's our current reality, and under the framework this bill proposes, we believe it will only get worse. This is an active shift in power, away from whānau, Hapai Te Hauora, and into the hands of corporations whose profits rely on our harm. And while this bill may appear to offer cost savings in the short term, it creates a long-term fiscal liability. It weakens the safeguards that protect our communities, undermines public health capacity, and strips back support for Māori and equity-focused approaches. So this means more harm, greater overall costs, and will further entrench health inequities. And those financial risks are just the beginning. They're made worse by the bill's constitutional failures, most notably its complete disregard for Te Tiriti o Waitangi.
And many people have already talked about that, but this bill constitutes a clear and serious breach of Te Tiriti o Waitangi. It is entirely absent from the bill. There is no reference to partnership, no recognition of Tino Rangatiratanga, and no protections of the rights, interests, or decision-making authority of tangata whenua. This is not a drafting oversight, it is a deliberate legislative decision and a direct contradiction of our constitutional foundations. When Te Tiriti is excluded, Māori are excluded and Māori voices are silenced. When Māori are not treated as partners, the Crown fails constitutionally and morally. We remind this committee, Māori are tangata whenua, and the Crown has a duty to act in partnership with us as enshrined in Te Tiriti o Waitangi. This breach reveals the political agenda behind the bill, and many have talked about this before us. The regulatory standard bill isn't neutral or purely technical. It's built on a clear political ideology, libertarianism, which pushes for less government, fewer rules, and more power to the market. At the heart of this ideology is individual rights ahead of collective responsibility, which again goes against Māori values and beliefs. Profit ahead of people, private property ahead of public health. These ideas might be sold as freedom or efficiency, but for us they mean more alcohol outlets saturating our neighbourhoods, more fast food chains creeping closer to kura and kohanga reo, relentless gambling ads and vape shops, even more targeting our rangatahi, unchecked corporate influence, and little to no regulation to stop it. These aren't hypotheticals, as Jason has already talked about. These are realities for our whānau, and this is what we see in our community, and this bill will only make it worse. It takes away the government's duty to protect people's well-being, especially those most at risk. It hands power to industries that profit from harm, takes it away from communities trying to protect their future. This bill doesn't just ignore collective well-being, it breaks down the very systems meant to keep our people safe. It deepens inequities, it undermines Te Tiriti, and it puts profit over people. We urge this committee to withdraw the regulatory standard bill completely, embed Te Tiriti o Waitangi in all regulatory and legislative processes, prioritise Māori public health and equity in all policy frameworks, and redesign legislative processes to enable meaningful Māori participation from the outset. This bill is not flawed, it is dangerous. It prioritises profit over people and leaves our most vulnerable communities more exposed. Withdraw the bill, honour Te Tiriti, and commit to a process that truly reflects partnership, transparency and democracy. Nō reira, tēnā tātou katoa.
Kia ora, thank you for your submission. We don't appear to have any questions, so again, I thank you, Jackie and Jason, for your submission and the work you do. Ka kite anō korua. Thank you. We're now going to hear from Darlene Tana, personal submission. Kia ora, Darlene. Welcome back.
Tēnā tātou.
We are in your hands. You have, you know the drill, but you have 5 minutes, but obviously encourage you to leave a bit of room for questions.
Tēnā tātou. Ko te mea tūtahi, ka mihi ki te rungarawa moana nei manaakitanga kia tātou katoa. Ka tuku mihitangi kia rātou ngā mate huhua o te wā. O te mārei kura ko takutai Tash Kemp tētahi. Moe mai, moe mai, moe mai rā. Kia koutou ngā kāmohi ora, tēnā koutou, he mokopuna tēnei o papatua nuku rau ko ranginui, e mihi kauana kia koutou. Ko Darlene, tōku ingoa, thank you very much for this opportunity to present. I won't repeat what's in my written submission. I would rather to use this time to lift some key questions and reflect on how this bill could, or what this bill could set in motion. And I'd like to start with a question about what kind of regulatory system or framework do we actually need in Aotearoa, and who should get to decide that. This bill presents itself as neutral, as a technical tune-up, I guess. But what it actually does is constrain future governments, restricts public investment, and sets up a narrow economic lens as if it's the only valid one. This bill rewrites the rules of lawmaking, and yet it doesn't necessarily respond to an actual problem. It doesn't meet the standards set out in the LDAC. Instead, it embeds a fiscal ideology while excluding Te Tiriti o Waitangi and collective rights altogether. It rewrites how law is made without asking the people who will live under it. That's not reform. That's a power grab. Imagine telling a community that placing rāhui or protecting wai is not consistent with good regulation. What happens when tikanga-based action clashes with cost-based principles? Are we prepared to defend cultural practice in court? This bill privileges private property and cost minimisation. It ignores tikanga. It ignores kaitiakitanga. And it runs the risk of turning our acts of care as tangata whenua, as communities, into liabilities. If passed, this bill could obstruct climate adaptation funding, kaupapa Māori investment, and even local government charges that support infrastructure. The principles necessary, reasonable, not oppressive, they sound tidy, but they're not defined. And that invites litigation. They hand unelected boards and courts increasing influence over elected decisions. And crucially, Te Tiriti is left out entirely. Are we comfortable embedding these principles so deeply that they shape cabinet advice and judicial reasoning for years to come? What message does that send, not just to Māori, but to communities all over New Zealand who rely on responsive, place-based governance? If regulation is how we care for each other, this bill treats care as a liability, and it leaves communities holding the risk. My submission isn't about rejecting scrutiny. It is about ensuring that scrutiny is fair, is representative and future fit. We need regulation that is grounded in relationships, in the realities of this place, and in the rangatahi who will inherit what we write. We need a framework that enables change and not blocks it. So I leave us with this. If we pass this bill, who are we making room for? And who are we shutting out? And that's not a technical question. That's a constitutional one. Tēnā tātou.
Cool. Thank you, Darlene. Appreciate that. We have met time, unfortunately, so we can't have any questions for you, but appreciate you making the time today.
Amanakitanga.
We're now going to go to David Clark. This is also in a personal submission capacity.
Kia ora.
Kia ora. Welcome, David. Thank you. You've got 5 minutes. I encourage you to leave a bit of time at the end for a question or two.
Tēnā koutou katoa, Chair, members of the Select Committee. Thank you for the privilege of being able to speak here today. My name is David Clark. I'm going to take my submission as read. What I want to address today is the question of why we are here, and to establish that there is no satisfactory answer to this question. The Ministry for Regulation received nearly 23,000 submissions on the proposed Regulatory Standards Bill, of which 0.33% supported or partially supported it. 0.33% is about 80 individual submissions out of 23,000. Clearly, there is something fundamentally wrong with a process where 80 voices in favour can outweigh the 88% or 20,000 voices opposed. In fact, an open letter written to the government by a group of prominent New Zealanders, including well-known academics and a former Prime Minister, referred to a process that is devoid of legitimacy. The Regulations Minister, without providing any evidence, has dismissed thousands of submissions opposed to the bill because an online campaign had helped members of the public to create submissions. He did not believe those submissions were representative of the general public's view of the bill. He chose to ignore those submissions, those thousands of submissions, not based on evidence, but because of his beliefs. This is the minister who wants to be responsible for making better laws. The party of the Regulations Minister has a disturbing recent track record of pushing through legislation under urgency and without due process. Using parliamentary urgency, the government has rushed through changes to the Equal Pay Act that make it harder for workers to make claims of unfair pay based on gender discrimination. Ex-Deputy Leader Brooke Van Velden announced the plan at 11 a.m. on Tuesday. Parliament was then asked to pass the law under urgency that evening. No one could reasonably argue that this is good lawmaking. A significant change affecting thousands of low-paid and mostly female workers effected under urgency with no opportunity for public input. Surely this would be a target for the Regulations Minister and is an example of bad lawmaking. In fact, the Regulations Minister congratulated Van Velden. The Regulations Minister responsible for the bill has himself been unable to articulate why we need this bill. In response to the widespread and almost unanimous opposition to this bill by many of our most educated and principled voices, instead of addressing their legitimate concerns, the Minister chose to publicly and personally attack them. If the Regulations Minister is unable to argue in defence of his own bill when challenged without resorting to personal attacks, why are we here? The Ministry for Regulation in its regulatory impact statement says, and I quote, "The specific legislative changes sought in this Cabinet paper are unlikely to be the most efficient approach to pursuing the stated objectives. It highlights that regulating in the public interest may be more costly, with an uncertain impact on the underlying behavioural incentives and on the information problems that drive poor regulatory outcomes. The Regulation Minister's own ministry has advised him the Regulatory Standards Bill is both unnecessary, more costly, and with an uncertain impact." In summation, the Regulations Minister dismisses submissions he doesn't agree with, makes personal attacks on educated opposition voices, has ignored the advice of his own ministry in order to progress this bill, and has congratulated his party deputy for passing legislation without following due process. Why are we here? We are here because of a backroom deal in the coalition agreement that has allowed a party with 8% of the vote to progress a bill which, based on public submissions, has 0.33% support. This represents a chasm between the minister's bill that purports to be about good lawmaking and actual democracy. And any party, minister or MP who votes in favour of this bill is absolutely complicit in this abuse of the democratic process. This bill has no value, no support, no credibility, no integrity, and should be consigned to the bin. Kia ora. Thank you.
Mark, we have got 30 seconds. Can you be that succinct? Mark Cameron?
Thank you, Mr. Chair. David, thank you so much for your submission today. Very grateful. Do you concur, sir, that the debt has grown inordinately in terms of the Crown? This is called Crown debt. And how do you square that with good or bad lawmaking in so much that you may or may not agree that there is duplication in law, and subsequent to that, this bill would be a way to ameliorate that extra additional cost, which is borne by the taxpayer?
I think that is completely uncertain based on the contents of the bill, and I don't think the purpose of the bill reflects those words that you've just said. It's not the intention of the bill to reduce the cost to the taxpayer.
Do we have a cost of living crisis, David, in New Zealand currently?
I don't believe that's relevant to the discussion that we're having.
Okay, we have met time. Yeah, sorry, Mark. Thank you, David, for your submission. I appreciate it. It's pretty short in 5 minutes.
Thank you.
Best of the day to you. We're going to go now to Dunedin City Council, which obviously will be an organisational submission of 10 minutes. Here we go. We've got Dunedin City Council there. Is that Carolyn and team?
Morning. Yes, you've
morning.
got Carolyn Kenton and Jessie Matheson.
Welcome. We've got you for 10 minutes. Really encourage you to keep it under that if for some engagement with members.
Great. Yes, so my name's Carolyn Kenton. I'm the Chief In-House Lawyer for Dunedin City Council, and I'm joined by Jessie Matheson, who is a Policy Analyst Māori. We'll aim to just speak for 5 or 6 minutes so that you do have a chance to ask us questions.
Perfect.
Just as an overview, DCC has a range of concerns about this bill. There are 3 key points that we want to discuss this morning. The first is that DCC is not convinced that the bill is necessary nor desirable. Many submitters have already identified there seems to be a lack of problem definition, and there are potentially other ways of strengthening legislative practices, such as through guidelines, limiting the use of urgency, using other committees. In terms of its desirability, DCC is concerned that the Clause 8 principles only include a selection of principles. DCC thinks that they're overly narrow. This council is particularly concerned that it doesn't cover off the principles regarding to te reti, and it doesn't cover anything in regard to environmental considerations. Given that there's no specific reference to te reti, that to us indicates that decision makers will not have to expressly consider the views of Māori. And that seems to us to be in contrast to what applies to local government. The Local Government Act specifically refers to the Treaty of Waitangi, and it specifically requires councils to provide opportunities for Māori to contribute to its decision-making processes. In regard to environmental considerations, the fact that they are specifically omitted, it appears then to favour private rights over public interests. The DCC is also concerned that some of the principles are oversimplified. One example would be the rule of law, which is a huge body of law and it's ever evolving. The other concern is that some of the principles are wide open to interpretation. So, for example, what does property mean? Is this only land or is it intended to be wider? For example, is it intended to cover mining rights? Does it cover collective property rights for Māori entities? What is meant by impairment? How does this sit alongside current legislation, such as the Public Works Act? Another concern is that the Regulatory Standards Board, there is a risk that it could become a symbolic or politicised forum for relitigating policy decisions. If there is a board, then DCC would like to ensure that there was broad representation and transparency. We note that the Chief Ombudsman has submitted that he does not see any compelling reasons why the board should not be subject to the Ombudsman Act. That seems a good suggestion. The second point is that if this bill is considered necessary, then this council does not think that it should apply to secondary legislation by councils. So the obvious example is council bylaws. Local authorities are already subject to rigorous legislative and procedural requirements. The Local Government Act sets out a comprehensive body of rules for council decision making. Those rules include requirements to consult with its communities, and it often involves hearing processes. The rules around council bylaws are particularly rigorous. Section 161A of the Local Government Act makes it clear that bylaws are secondary legislation. Under the LGA, when a council makes a bylaw, it must demonstrate that the bylaw is the best way of resolving the problem or issue, and that a bylaw is a proportionate response to the problem or issue. The council must ensure that the bylaw is not inconsistent with the New Zealand Bill of Rights. The council can only make bylaws for certain purposes and about certain things, and it must consult, often through the special consultative process. That means that there is a submissions process and hearings. So council is already subject to a comprehensive regime in regard to its bylaws. Adding this compliance layer seems unnecessary, particularly when there doesn't seem to be any problem definition around council bylaws. As far as I'm aware, this is not, it's not a subject that has created wide debate. Effectively, what it would mean is that it's duplicative and it's going to add costs, which, and there's some irony in that, in the sense that the bill purports to be trying to get rid of red tape. The main obligation and cost would be the obligation to prepare a consistency accountability statement. The third point is that if the bill is to apply to local authorities, then we need to be clear about what will be captured by the ambit of the bill. So I've spoken about bylaws. That's a clear instance of secondary legislation. But there is a section in the Local Government Act, section 161A, which says that any other instrument made by a local authority or a council's controlled organisation is secondary legislation if it has significant legislative effect. Now, there's a separate section that explains what significant legislative effect means, but it's potentially wide. I understand that when it was created, the intention was to have a high threshold, but nevertheless, DCC is keen to avoid any disputes around what it actually means. So if you look at, for example, the district plan, we wouldn't ordinarily regard that as secondary legislation, but we don't want to get into disputes about that. And you know, there are sections in the RMA that says rules and district plans have the force and effect of a regulation. So the risk is that this legislation creates disputes, it creates costs, and it creates uncertainty. So for DCC, we support improving regulatory quality, but we have significant concerns about this bill. If this bill is to proceed further, then we would like to have the local government perspective considered further. We'd like to have these concerns worked through in collaboration with local authorities and other stakeholders. Thank you. We're happy to answer questions.
Very good. Thank you. I've got one from Francisco Hernandez.
Thank you, Chair, and thank you, submitters. I have a question around the sort of the secondary legislation aspect that the DCC administers. Approximately how many pieces of secondary legislation would you say that the DCC currently administers, and what additional resourcing do you think it would take if the DCC were required to review them?
I haven't counted the exact number, but I would guesstimate about 40. The additional cost would be in relation to the process, and my concern is more around the fact that you have specific provisions in one piece of legislation, and there is the risk that they are going to collide with the requirements under this bill.
Thank you for that. It looks like the blue sky's trying to break through in the background there. But what a fantastic submission, some pragmatic points. So thank you for your time today.
Thank you.
Well, thank you.
We're now going to go. We've got John McDonald Whare, I think, making a personal submission. I can see you there, Dr. John. Oh, you just turned your audio back off. Yep, and your video, if you could turn that on. Can you hear us?
Kia ora. Yeah.
Kia ora. Welcome. Great. We've got you for 5 minutes, sir, so we'll get you straight into it. And if we've got time, we'll have a question at the end.
I'm here to defend many of the principles, rights and values mentioned in the bill rather than the bill itself. The current bill is weak and has serious flaws related to conflicts of interest. The current bill appears to provide another largely toothless oversight function which the executive branch can ignore when it moves to further violate the rights of people in this country. I liken the current bill's proposed board to the compliance and Section 7 reports from the New Zealand Bill of Rights 1990. And in that context, overall, the Attorney General, Ministry of Justice and Crown Law have done a shoddy job using that mechanism of protecting the rights of New Zealanders from dubious legislation and overreach by the executive branch. Given that it's likely the minister who has control over this proposed board is likely to be voting in support of any new legislation which is a serious threat to people's rights, the minister potentially has an extreme conflict of interest. And that minister in the current bill is given the harsh and arbitrary powers to dismiss the board or stack the board with favourable people. I have proposed some alternative options to that. So if you turn to page 7 of my document, I've proposed that you move the functions that this board is meant to be providing from under the executive branch controlled by the minister to the legislative branch. So a major change would be you create a new House of Parliament, upper house or something, which focuses on these constitutional matters and make sure new legislation is consistent with the Constitution. Or you create another office in Parliament or something like the Parliamentary Commissioner for the Environment. You create a Parliamentary Commissioner for Constitutional Consistency or an Office of Constitutional Consistency, which reviews legislation and files reports to the legislative branch about whether it's consistent with the various constitutional enactments which are foundational to this country and whether rights are being respected. On a more enforcement side of things, you could create a new part of the judicial branch. You create a constitutional rights review tribunal, similar to the Human Rights Review Tribunal, the Waitangi Tribunal, which sits there and has powers to examine current and proposed legislation and declare it inconsistent and hand out penalties in the cases of arbitrary use of powers and executive overreach. This bill has prompted some wider discussions about New Zealand's constitution and the Treaty of Waitangi, which I'll take a bit of time to address. So New Zealand's foundational documents related to rights and liberties are listed as constitutional enactments in Schedule 1 of the Imperial Laws Application Act 1988. So it covers Magna Carta, Petition of Rights, Bill of Rights 1688. It goes all the way back to 1275, where they talk about the common right being done to all, as well rich as poor, without respect of person. So we've got equality before the law, and we've got rule of law entrenched in New Zealand constitutional enactments, still on the books. So we don't necessarily need these restated. We just need to have a branch of government actually taking them seriously. This ties into the Treaty of Waitangi because the Treaty of Waitangi, Article 3, talks about the rights and privileges of British subjects. We need to be having a national conversation focused more on what are those rights and privileges of British subjects and why were they so important in the Treaty of Waitangi that the chiefs ceded special powers in Article 1 to gain those rights and privileges for the country in Article 3. And I think there's a deficiency in both our treaty and te tiriti education and our public discourse about it, that we're not focusing on what those rights and privileges of British subjects were and where to find them in the Imperial Laws Application Act 1988. I also note the strong language in a lot of those documents, like the Bill of Rights 1688, compared to the sort of weaselly clauses in the Bill of Rights 1990, where the government, for policy objectives, can ignore rights.
Dr. John, we're nearly at time, so I'd actually ask you to, if you could draw your submission to a close.
Yeah. So I think that public discussion needs to head off in that direction about what are those rights and liberties of British subjects, and is the government respecting it, and do we have adequate accountability mechanisms?
Okay. Well, thank you for your written submission, which is quite fulsome, and also your oral submission today. Really appreciate it. We're now going to go to Environment Hubs Aotearoa, which is an organisational submission. Just give them a moment to pop up. Has that come up as Beautification Trust, Liam?
There we go.
Oh, there we go. Name change, just like that. Kia ora and welcome. You've got 10 minutes and just encourage you to leave a bit of time at the end for some questions and answers in your hand.
Absolutely. Thank you so much. Firstly, thank you so much for inviting me here today to talk about the Regulatory Standards Bill. My name is Sterling and I sit on the board of Environment Hubs Aotearoa. So who are we? Why are we here? We're a national network that supports 21 hubs across New Zealand, Aotearoa, and all of us are focused on empowering local, community-led environmental regeneration projects. So our kaupapa is rooted in community. It's rooted in environmental protection and also honouring te tiriti. And I stand here representing a network which spans 400 people employed across Aotearoa through our hubs. In the previous year, our collective impact has seen roughly 300,000 native trees planted. We've rescued 2.4 million kgs of food, 35,000 tonnes of waste diverted from landfill, more than 125 hours volunteered, and more than 45,000 rangatahi engaged with our hub programs as well. All of that to say, we are the feet on the ground. We deliver on environmental and community outcomes, and we are all here to oppose the Regulatory Standards Bill in its proposed and current form. So for us, regulation matters more than ever. We're living through an interconnected environmental crisis. We have, in the last few years, seen floods, we've seen biodiversity loss, we've seen major cuts and slashes in funding towards our community projects as well. We believe it's not a time to weaken protections. We think that regulation must balance economic, social and environmental outcomes. For us, bad regulation prioritised short-term profits, whereas good regulation safeguards our future generations. And there's a Native American quote which says, "We do not inherit the earth from our ancestors, we borrow it from our children." And this thinking truly exemplifies what kaitiakitanga is in principle. It's a shared vision across Indigenous cultures of the world, and I believe that this Indigenous thinking has been completely ignored by the proposed bill. So some of the problems and concerns that we have, we think that the flawed process has undermined the trust, and especially with our communities, within our communities. The bill was introduced over a holiday period, which limited its public scrutiny. When it was introduced, our team barely had enough time to read through it or understand it or find places that we could learn about it. And I was surprised to see that there had been some redacted sections already, the first time I'd seen it. And we think that a bill needs to have cross-party support to ensure stability and longevity. I think if it was a truly helpful piece of legislation that would help streamline processes and decision-making, the fact that it needed to be pushed through last minute, especially on the tail of the Treaty Principles Bill and the Fast Tracks Approvals Bill, was like, it's just so unsuccessful. And it feels like it is just another attack on our processes. And in all honesty, I would really love to stop making all of these submissions on all of these different bills, although the benefit has been that suddenly everybody in our organisation is really, really good at making submissions now. So the public participation has been an amazing thing. However, the repeated attempts to push through other similar legislation just signals that the support for this bill is low, as it was with the other ones as well. It seems like an expensive piece of work. It's a waste of money, and it truly is a waste of time. Our next concern is around regulating for the few and not the many. The regulatory standards proposes complaints about environmental protection risks, dismantling the hard-won safeguards through our environmental acts. Our Māori collective rights, marine reserves and the environmental laws could be reinterpreted as infringing on property rights. And we think that it paves the way for a system where individual profit trumps collective well-being.
Catherine Chung, who is from the Climate Justice Taranaki, states that by putting liberties, rights, and private properties as principles over and above obligations and the protection of the commons, the Regulatory Standards Bill could force the rewrite or change the meanings of many existing laws and regulations and threaten any safeguard for the environment and communities. So my kind of thinking behind that is, what do the many want? So if this is for for everybody, like what do our community think about this? And as someone who works alongside our beautiful community, I see how passionate our people are about the environment. What they want is actually a government that is as passionate as they are about looking after people, environment, and future. So our people want to protect the environment. They volunteer time, energy, and hours to work towards restoring rivers to swim in, to harvest food from the ngahere in the forest. They don't want to worry about things like pollutions, the things that might come into to harm some of the projects in the areas that they're thinking about and have been protecting for a really long time. Our community have been kaitiaki of awa and maunga and moana, and their efforts should really be highlighted. We don't want them to go to waste in pursuit of individual profit. Our next point and worry was around the silencing of the community and our local voices. So this bill weakens local authority regulation and community advocacy. And our hubs could lose the ability to push for stronger protections on behalf of our communities, which might lead to the erosion of civic voices, just going towards democratic fatigue and disengagement. And I've seen that at the ground level as well. It's really, really disheartening to see people who are very disconnected from our laws and just our civic processes that we have in place, because whenever they engage with it, they see it as a personal attack, and it's not nice to see every day. It seems, a lot of my job is just creating and revising submission bills, doubling back to protect our community environment against harmful legislation just means that we're taking away from the projects that actually matter on the ground. And our community really deserves a chance to be heard, and it deserves to be engaged with proper timelines and time allocations as well. The next point that we wanted to make was around Te Tiriti o Waitangi, which is a living document, not a checkbox. Our treaty should be a guiding principle in lawmaking, not an afterthought. The redacted part of the treaty assessment impact was a big red flag. So why was it hidden? What was it? What did it contain? Any bill that reshapes the nation must uphold the mana and the rights of tangata whenua. And I think you have all heard the quote, he waka eke noa, we're all in this together. It seems like the head of our waka is steering us straight into a storm, and we're just fighting amongst ourselves. It's at odds with our mana whenua, and this bill purposely ignores the treaty, which is the unifying document that binds us together. And our Māori traditions and knowledge are the things that should be guiding us as a nation. They're a point of difference in a country, and we should uphold and protect and celebrate it. So instead of going back to the drawing board to, rework this bill, I really would suggest that we throw it out and stop trying to undermine the power and authority of the treaty. It doesn't need any more legislation. It's a beautiful thing that we should be upholding. And the real cost of weak regulation, this bill proposes, it risks long-term damage to biodiversity, water, air quality, climate resilience. It prioritizes the wealthy few over the well-being of the many now and into the future. And we're at a tipping point where this bill might tip us backwards. So in conclusion, we stand with all of those who have rejected the bill in its past attempts. We urge decision makers to protect the commons, protect the community, protect the future. In short, Hubs Aotearoa does not support the Regulatory Standards Bill. And my final call to action to our MPs and anyone listening is to go and visit your local hub and see how passionate they work. Listen to how much they care about their whenua and awa. The collaborative regulation and environmental protection as it currently stands can achieve significant outcomes despite cuts to funding and continual disruptions to the projects. And we want to cherish our relationship with mana whenua, uphold their intentions for the whenua, and we really just want to protect our land and safeguard our futures together. So with all of that, thank you.
Thank you for that submission. We've got a couple of minutes. I'll go to Mark Cameron first.
Thank you, Sterling. What a wonderful submission. I'm genuinely very grateful that you care for the environment like so many people do. I do have a slight difference of opinion when it comes to the rights of individuals versus collective groups when it comes to property. But how just the question I do have, Sterling, is how do you square the fact that we have currently a set of legal frameworks that are accepted regulations in terms of base discharge limits, or what can be done to the environment at a certain level? Do you believe that the current regulatory bill that is proposed, the standards bill, will remove those current regulations if they're working? Is the question I have. Do you see that as a threat to working regulations currently?
I do. I think that a lot of the regulations mean that if we made decisions now in the future, our threat is actually that we can't reverse a lot of those decisions, which get made pretty much now. I'm really worried about how we have tried our hardest to do projects that fit within this particular framework, our legal framework as it is right now. And we see all of our environmental laws and protection laws as something that's really something special. It safeguards projects, it safeguards the future and the viability of different things which can and can't happen on the whenua. And when we think about having less strong input from local councils, mana whenua, community, it's just like really disheartening, I suppose, to see that. So, yeah.
Sterling, just very quickly, what about bad regulations though? Duplication, extra cost. How do we ameliorate that? And do you see there's a correlation in this bill?
Maybe. I just think that from what I understand about our current lawmaking processes, and I'm not an expert, I think that the way that we do things now, we do it to a particular degree of quality. And I like the part of our lawmakings where you have to have empirical evidence that your new policy or your new law, or the proposed things that you have in place, will actually make a difference in the future. I think that that's amazing. And I think that this law actually has completely ignored that as well, because I don't think that there has been any of that consultation at all.
We're going to have to leave it there. I'm sorry. We're actually at 12 minutes now. So thank you for your submission, Sterling, and the work you do in that space. We're now going to move to Jan, who's coming online, making a personal submission. And we've got one more submission after her, and then we'll break for a short lunch, committee members, which I'm sure you'll be looking forward to. Welcome, Jan. Just got to unblock your audio. There you go. And video.
Thank you for inviting me to speak.
You're welcome. Have you got video function available, Jan?
I am defeated by the technology. I'm sorry.
That's okay. We're in your hands. We've got 5 minutes, so you're welcome to use that time up or leave.
Here we go. Here we go. Right, that's better. Okay,
welcome.
Sorry. Okay. Yes, tēnā koutou katoa, and kia ora to the previous speaker. That was inspiring to hear. My submission opposes the Regulatory Standards Bill, and I've got two main points. The first is that it places individual and corporate interests and profit above the common good, and in doing so it ignores the Treaty of Waitangi, which is our foundation document, and has no particular provisions for environmental protection. So these are aspects of the common good which I'm concerned about, which are not specifically mentioned. My second point is that it's undemocratic in that it's based on the tenets of a minor party, and it doesn't necessarily incorporate the broader views of New Zealanders. As it applies to legislation and to local government, it's not taking into account that each piece of legislation would have its own goals and its own underlying principles or values, which could be stifled by a blanket approach. So it preempts debate on a case-by-case basis by assuming that the same things would be at stake in every piece of legislation, i.e. property and profit. And that doesn't really consider the well-being of a large number of New Zealanders who have neither property nor profit and would be more interested in their rights, their well-being, and the health of the environment. However, the more I think about and read about the bill, and as I've heard from previous speakers, I'm less convinced that we need it at all. There are processes and guidelines already in place for legislation, Cabinet's legislation guidelines for best practice, Treasury, vetting by justice officials and Crown law to ensure that there's a fit with the Bill of Rights. So these processes are already there. I'm a little surprised that a party which is very vocal about efficiency and reducing red tape would think it necessary to add another layer of bureaucracy on top of all of those. Referring again to the guiding principles, I think if we are going ahead with such a bill with some overarching guiding principles, I think there should be wide consultation on what those should be. I'm a Quaker, and we use values such as peace, integrity, equality, concern for the community, concern for the environment to guide our actions. Personally, I find these good values and they're useful for orienting myself in the world and in my life, but I wouldn't impose them on the whole country without consultation. Most people have their own thoughts on what their guiding lights are. So I believe if the bill is to go ahead, there should be a wide consultation, including as many aspects of society as possible. So that would be iwi, workers, families, religious groups, and so on. And I think the model of citizens' assemblies could be used. This would take time and consideration, but a slower process could lead to better legislation rather than binding people to principles that may not apply in the future. So my points are either we don't need the regulatory standards bill at all, or if it must be done, we need to consult much more widely on what the underlying principles and values that New Zealanders as a whole want should be.
Thank you, Jan. Appreciate you taking time out of your day to make your submission very succinct. There don't appear to be any questions, so we will move to our next submitter, but enjoy the rest of your day.
Thank you very much.
Ero Limited, our final submission before a brief lunch break. Arihia, is that you?
Kia ora.
Kia ora, welcome. And we've got you for 5 minutes, please, in your hands.
Ka pai. I thought I was on for 10 minutes, so I'll try and sync to my kōrero as much as possible.
You're right, actually. There is a 10-minute. You are part of an organisation. My apologies.
Kia ora, thank you. O tēnā tātou e te komiti kua rihia hoani wā ka tōku ingoa. I won't bore you with a full introduction today because we've got limited time and I understand you want to get to lunch. What I will say, though, is that Ero Limited is a company or a kaupapa based out of Rotorua that has the privilege of working with iwi and hapu across the motu and also working in a space of translation of iwi and hapu rights into council spaces and vice versa. Our big work is really in enabling our people to participate in council systems and processes, and also government systems and processes, which is a critically important part of the future and shaping the future of Aotearoa. I've got a few points, but firstly, I'd like to say that I'll take our submission as read, and I'd like to reaffirm that we do not support the bill or any amended version of the bill, and we request that the committee recommends that the entire legislative framework is removed. Interestingly, the bill to create better oversight in the interest of good lawmaking has failed to give enough time to accurately understand and form positions on the bill. expediting processes on a bill that is largely technical in nature and for which it would be difficult to understand the long-term impacts of is very concerning. Further, the bill's nature and scope are so large that repealing it will prove difficult due to its level of influence over not only incoming legislation, but also existing legislation. We work in a suite of different environments that encourage the engagement of our iwi and hapu in the system to ensure influence and encourage the upholding of the rights and interests of our iwi and hapu. And obviously that's on the back of the Waitangi Tribunal's findings in Te Papa o Te Raki that we never ceded sovereignty. The reality is that the ability of the majority of our iwi and hapu to understand this bill in detail and participate in this process effectively has been significantly constrained when they're given 28 days and have large portfolios for which they are responsible to consider the impacts of this bill on. The principles of Te Tiriti o Waitangi were not developed unilaterally. And when you look at the principles of this bill, it's quite the contrary. The principles of Te Tiriti o Waitangi emerged over time through intensive consultation, Waitangi Tribunal inquiries, judicial findings, and were grounded in constitutional obligation of the Crown to act as a partner under Te Tiriti o Waitangi. In contrast, the Regulatory Standards Bill proposes principles derived from a single political ideology without public consultation or treaty-based engagement, undermining both democratic process and tiriti partnership. The fact that all legislation has to then be tested against the unilateral principles and further ministers will have to produce consistency statements is absurd. Attempting to create a reverse Waitangi Tribunal is absolutely unreasonable, considering the Crown is constitutionally already the other party to Te Tiriti o Waitangi and has accountability mechanisms for their practices in the judicial system of the courts, Crown law, advisors to ministers, for which the Minister of Regulation has ignored in the development of this bill, and public submission processes to create levels of accountability. The point that has been attempted to be made by the ACT Party in relation to this bill is that the reports of the Regulatory Standards Board are non-binding. As we know, the Waitangi Tribunal also has a non-binding nature, and so therefore I'd like to raise that while the Waitangi Tribunal is non-binding, they have had influence. For example, Y11 in 1986 resulted in the Māori Language Act 1987. Te reo Māori is a taonga under Article 2 of Te Tiriti o Waitangi and must be actively protected by the Crown. The legislative result was the Māori Language Act 1987, which gave official status to Te reo Māori and established the Māori Language Commission, Te Taurāwhiri Te Reo Māori. Another way that it might influence in terms of indirect influence on law or policies was the Tribunal's finding that the Crown failed to uphold Māori rights over Indigenous flora and fauna, mātauranga Māori and intellectual property. While there was no legislation directly resulted, or none has resulted yet, Y262 has shaped the Ministry for Business, the Indigenous IP policy, Ministry for Business, and the Mātauranga Māori Advisory Panel for Environmental Science. There's also ongoing legal debates about data sovereignty, mātauranga, and benefit sharing. So to say that a non-binding regulatory standards bill won't have as much influence is absolutely incorrect. We know that they will have an influence on how legislation, policy, and everything else in this country progresses. I would like to also note that this is basically creating a space for a large-scale media campaign. The Minister for Regulation's recent Victim of the Day posts prove it, that all findings will become part of a process to sway public opinion as measured against politically driven principles. For example, we'll see that the Regulatory Standards Board will have some findings and we'll have a nice little social media campaign about why it's incorrect to sway the public opinion without considering that it's measured against the ACT Party's own politically driven principles that form what the weight of the Regulatory Standards Board is measuring against. As a small point on regulation, because we do work in the environmental and urban planning environment, it is important to note that regulation is a core function of government used to uphold public interests, protect the environment, and give effect to te tiriti. The RSB reframes regulation as a problem, not a tool, prioritising economic efficiency over constitutional and collective responsibilities. New Zealanders everywhere love the ability to enjoy awa, swim in the moana, head out to the ngahere, and where regulation isn't enabled to address or protect against long-term issues, this becomes a problem for all of New Zealand. Regulation is particularly necessary now because we have kids swimming in rivers across the country whose reading for E. coli is in an attribute band E, when the scale is from A to D. I have sat in marae with communities across the country who have cried tears when they have realised just how dirty their rivers are that their children swim in, places that they used to gather for and undertake specific ceremonies such as tuhi, pure, and karakia, where they used to birth their children in rivers, now physically unswimmable due to the amount of pollution that exists in those water bodies. We should therefore be encouraging an enduring environment that all New Zealanders for all generations can enjoy, and that comes from good regulation and a commitment to support everyone in New Zealand to achieve the regulatory standards. Finally, on a point of cost benefits, which is a key part of this bill, we live in a country where sometimes cost does not provide direct and immediate benefits because the benefits are long-term. An example of that would be our kohanga reo, for which now we see the long-term benefit of exceptional Māori who know who they are, they know their language, and the benefit in terms of contribution to the nation has been realised much later than the 5-year-old who enters into a kura system with a strong sense of identity and their language intact to carry them through life. The reality of this is that kohanga addresses the abuse and colonial violence on our language, and it is the people which take generations to correct. So when we have a damage like this that occurs to our people through colonial violence, it's a long-term process. It's a generational process to, I guess, start to repair some of the damage that's been done. And therefore, the contributions to the nation or the direct cost benefit would be extremely slow and would be heavily criticised by the Regulatory Standards Board and likely the public or publicly shamed by the Minister of Regulation in his Victim of the Day posts. I don't have much else more to say. I know the submission was 29 pages, but you can't really cover that in 10 minutes, so I'm happy to take questions.
Thank you, Arahia. Yeah, very comprehensive. It looks like there are no questions, so you've obviously done a good job of presenting your points across. So we'll leave it there, but thank you again for making the time.
Kia ora, thank you.
Kia ora. Members, we'll break now until 1 o'clock. See you then. Thank you.